Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will guide you through this 3-hour journey through Courtlandia. We start in Lenawee County, Michigan. This is Judge Anzalone.
This is the date and time set for show cause. It was turned over from the other day. Mr. Lewis, let's see. Your original show cause. So I've been adjourning this out like 5 years, but you do make payments, and that's why I do it. So originally it was $11,365. It says 2021. It's gone down about $1,000. This is your 26 show cause. We got a $58 payment. Mr. Lewis, we ordered you to pay $200 a month. I'm going to need you to start making these payments, or I'm going to have to bring you in person or issue a warrant, Mr. Lewis. You're at felony level now.
I'm at felony level now?
Yeah. $10,000. They can charge you with a felony. That means you wouldn't be able to coach anymore.
I just made a payment yesterday, and I made the $200 for the month.
Okay. You made it online?
Yes. I have a whole... Hold on, let me pull up the payments history. Okay. Yeah, make them online through Apple Pay.
Okay. Do you have a receipt number or reference number?
Let me get that for you. Real quick. Yeah, so the 16th, the number is 52765 000. It was 102. And it says it didn't go through. Then I tried to make another one on the 16th for 7688, and it's saying it didn't go through. And then today's is 570-630-32, and that was 2574. So that made it 200. It said that one went in, but for some reason the other ones did not.
So, Mr. Lewis, obviously I don't want you charged with a felony. I'm sorry, she's throwing stuff around. So, but, $200 a month. Do you have other children?
Yes.
Okay. It's not the highest child support. When you work in such a way that I don't think we get income taxable holdings, but it's not a lot to ask. So what I'm going to do is I'm going to adjourn this one more time, but if you don't make the payments, I'm going to order that you appear in person. Okay.
Okay.
So Mr. Lewis, I am going to adjourn this to August 21. I want a July payment of 200. I want an August payment of 200 a week, at least 7 days before the court hearing. Because if you do it like a day or two, we can't verify it till it enters the system. So you need to make a payment by August 14, and then you need to make a finish your $200 July payment. I'll set it for August 21. If you have not made both of those payments, I'm going to order that you appear in person. And if you've made both of them timely, you can appear via Zoom. But, Mr. Lewis, I can't keep adjourning it when you're not following through. So August 21. Appear in person if both payments are made by August 14, or appear via Zoom if both payments are made by August 14 in person if they are not. You understand?
Understood.
And you are facing up to 90 days in jail, which, you're a football coach. Season's going to be kicking off soon. So we'll see you back on that day. Thank you. All right. So, what's your name?
Alejandro.
Madrid? Come on up. All right, in file number 2018-45407DP, this is in the matter of Tara Sharp versus Alejandro Madrid. Sir, nope, you didn't even bother to sit down. This has been adjourned to August 21. You must be making payments.
Yeah.
So if you want to, I required that front of the court contact people if it's adjourned on Friday. I don't care how late on Friday. So if you are concerned that your phone number is not updated, stop downstairs and update your phone number.
What day is it?
August 21.
All right.
It's like a Monday in August. So, but give them your valid phone number because they are required to call and let you know so you don't have to show up.
Okay.
But that means you got to keep your voicemail empty too. All right. All right. Thank you. All right. Mr. McAnally. So file number 2013-39382DM, Shalisa McAnally versus Michael McAnally. This is the date time set for a show cause. This one's like 2 years old, 2.5 years old. At the time of the original show cause, you had an arrearage of $9,389. Today's date is $12,392. This is your 7th show cause. We did get a payment in April for $40. You did turn in your paperwork from Cooper Bender. What's the progress on that?
I got denied. So we're in the appeal process at the moment. So
you got denied and you're on the appeal process. Okay. All right. And you understand that you still have to make your payments.
yes, I made a $200 payment today, and I did pick up a job. It's out of town. I did have to relocate. I did end up losing my apartment in Tumsey, so I had to relocate. But I did pick up a job. It's in Westland.
Westland, yeah.
Yep, Westland, called Colmat.
Okay, so what I would like you to do is take that down to front of the court so they can make a copy of it, so they can do an income withholding. And then good luck on your appeal. I'm gonna set this out to August 21 at 8:15 in the morning, all right? Make sure they have your phone number, because if you're making payments, they can just adjourn it out and call you the Friday before.
Thank you.
All right, thank you. All right, Ashley Hahn versus Jamal Davis. This is file number 2017-44030DS. I have Miss Hahn, but I do not have Mr. Jamal Davis. Let me find him. So, Jamal Davis was ordered to appear. He's failed to do so. This is a show cause from the beginning of the month. His arrearage is $16,230. It's the same today. This is for a show cause. He paid $20 back on November 12th. He was receiving SSA benefits, but he's no longer receiving them.
Oh, he's not.
Is not?
Oh, he's not.
Well, okay, so this is what it says. Are you still receiving them
I don't get anything.
for the child? Oh,
No.
all right. So the defendant was receiving SSA benefits. However, a letter from the Social Security Administration on April 26th stated that is no longer the case. He has only made one $20 payment in the last 24 months. The charges have been lowered to $4 for 16 months. Payments were not received in that time frame either. There's only been 6 months payments in the last 13 years. So I'm going to issue a bench warrant for his arrest for failure to appear. And I'm going to set bond in the amount of $5,000 cash. All right.
And Your Honor, the $20 I only received because his mom came down here to pay on his probation and she put it on the wrong thing. That's the only reason I got $20.
All right. Well, I'm sorry. Thank you. All right. Mr. Madrid. Michael Madrid, come on up. All right, 2020-47630DS. This is in the matter of Abigail Craig versus Michael Madrid. Mr. Madrid is present in person. This is a show cause stemming from September 30th of 2024 that the court's been adjourning. Mr. Madrid is ordered to pay $342 a month in child support. His arrearage two years ago was $15,089, and now it's $17,777. This is his fifth show cause. Total payments, $2,500. That was posted on March 3rd. You're ordered to pay $400 a month for the months of March and April. We haven't received payments. Do you have payments today?
Yes, ma'am.
What, did you pay it? You got a receipt?
Yes.
Is that, 800?
Yes, ma'am.
Awesome. You know, Mr. Madrid, if you just pay it, then we don't have to make you come back. I know.
Just keeps me in line, kind of.
Okay, well, all right, shows he paid $800, perfect. All right, so, I'm gonna set it out to August 21 to keep you in line, I guess, and, pay the $400 a month. Make sure friend of the court has your phone number. If you pay it before the day, then you just adjourn it so you don't have to come back in. All right, stay cool out there.
Thank you.
Thank you. All right, in the matter of file number 2021-48796 DC, in the matter of Catherine Baldwin versus Brantley Tubert. This is a date and time set for a show cause. Mr. Tubert was ordered to appear. He's failed to do so. I'm going to issue a bench warrant for his arrest. I'm going to set bond in the amount of $7,400. All right, and let's see, let's go back up. No, I didn't. All right, in the matter of file number 2017-44002 DS, in the matter of Diana Cruz versus Matthew Davis, this is a date and time set for a show cause. Mr. Davis was ordered to appear. He has failed to do so. He has made no payments in the last year. I'm going to issue a bench warrant for his arrest for failure to appear. I'm going to set bond in the amount of $7,000 cash. Right? And I believe that concludes. What's your name?
Mike Puckett.
Say it again.
Mike Puckett, I live with next court. She's going on with my daughter.
What's your daughter's name?
Bethany Puckett.
Mr. Carlin's case.
Okay.
You just want to say talk to them about.
All right. Well, I do believe that concludes our court show causes.
Alrighty, friends, good morning once again. It is TCF Live on a Monday. It is good to have you all here with me. Let's stay in Michigan, but we'll head up to the Thumb. Judge Prill.
State of Michigan versus Jordan David Larson, 3 files, 23/70/19/2021. Time of day set for sentencing. Defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Wachowski. Back on June 1st of this year, the defendant had entered a plea to a violation of probation. Ms. Mandy Alexander has prepared an updated report dated May 12th. Ms. Weisenbach, have you and your client had the opportunity to review it?
Yes.
Any additions, deletions, corrections, or objections?
No.
All right.
Okay, I do have something. Page 7 of 8. The section evaluation and plan, first line says it's been a sentence out of the 53 circuit courts.
I didn't see that.
Okay. So.
When did you get up? I believe that's Judge Stikowski. I believe that would be
You're very
absolutely
good
serious.
numbers I am not.
That would be what's side of the state. Okay, that correction's been made. Anything else?
Thank you. No.
You reviewed the report as well, sir, obviously.
Yes.
Anything else other than what Ms. Weisenbach has stated?
No.
Mr. Wachowski, anything to be asked of people relative to the report?
No, Your Honor.
Thank you. Ms. Weisenbach, what would you like to say to have your client before the court?
Thank you, Your Honor. Well, I met Mr. Larson at the tail end of what was an unfortunate spiral because he had quite a bit of opportunity with recovery court, and then even after that, I was a little surprised to read that there was a little more of a break following that. But unfortunately, he was not in a good place. He was with a bad crowd. He knows himself. He knows what he needs to do. And the guy that I did meet was clear-eyed, well-spoken, polite, cooperative, probably not what you had been dealing with before. That's what I'm going to guess. But the guy that I talked to is ready to get all of this behind him. He's young. He just needs to get this 3 years of whatever's going to happen here next done, over with, and way behind him in the rearview mirror. He knows he's going to prison. We've had this conversation. The prosecutor's office dismissed the misdemeanor because this is where everything's going to land. So he's going to use that time wisely, start right off with trying to get his GED, sign up for everything he possibly can in the prison. As the court's aware, they will triage they have small amount of programs, they triage the ones that are almost getting released, which is kind of going to be him in that spot if this is done well today. So he's going to keep busy with doing all that stuff. His past was he was a good athlete, a good student, star athlete, really needs to get back on track. There was a good kid there. There was a bad patch, and that needs to be done, and he knows that. So with that being said, we have done all the numbers. If you follow the recommendation, he'll probably be in prison just a little less than 3 years. That could get him into a lot of programs and keep him moving in a good pace. So again, the guy I met probably is a lot different than what you've been dealing with, but this guy is ready to get this all behind him. Thank you.
You're welcome. Sir, is there anything you'd like to say?
That's why I pretty much started off, just ready to get this all behind me and start living life the way I should have been in the beginning, and start doing things the right way. Just want to apologize to my family, for not doing what I was supposed to.
Thank you, sir. Mr. Rakowski, man, people.
Your Honor, we're asking to sentence Mr. Largent to the top end of the guidelines, and that's the 40 months. And the reason for that is Mr. Largent was given the opportunity of having some regional recovery court. And the court notes the violations, which then led to his removal from the court. And then he was brought back for sentencing, which the guidelines were prison. So we asked for prison, and the court gave him another chance. And at that time, I'm sure it was because of the argument that he's trying to do better, and yet here we are again. So I think under those circumstances, Your Honor, we're asking you consider the 40 months, given all the chances have been allotted to Mr. Largent.
Thank you. And that's the unfortunate part because, there are cases that even I just get confronted by individuals saying, well, you did this and you did that. I understand that. Part of sentencing is with rehabilitation. That's the goal. We don't want these individuals to come and reoffend, come back before the court, having other victims involved. The whole idea, there's punishment, deterrence, rehabilitation, all those factors apply. Those have been offered to the defendant in this case. And sadly, they were not completed, but I think looking forward in this case to see a new attitude by the defendant, as stated by Ms. Weisenbach, as well as Mr. Largent himself, indicate to the court that he's going to take this time and reflect upon it, hopefully learn from it, and not be in this courtroom or any courtroom in the future. But opportunities have been given. Sadly, they were not completed, and it just goes to show that at least you look at all aspects of sentencing when determining how to move forward, and the court had given opportunities. Sadly, they just weren't completed. That's in this court that the defendant is unsuccessfully discharged from probation. All monetary obligations are still due and payable for the defendant here to the court, and the guideline range, though probation violation may not necessarily apply, but the court considers the guideline range, and the guideline range at a very maximum is 40 months. And it will be the sentence this court, the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody for a period of 40 months to a maximum of 20 years, credit for 441 days served. It's my duty to inform the defendant he has right to seek leave to appeal. If he's finding he has been able to provide counsel of his own choice, the court will assign counsel for him at public expense. He's to initially receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. in receipt of the notice of right to appellate review. It has been signed by the defendant dated today's date. Mr. Largent, taking you at your word, take this time now, learn from this, take advantage of any and all programs within the DOC, and I'd rather see you on the street, productive, doing the things you need to do. Good luck to you. Off the record.
Thank you.
Alrighty, friends. Once again, good morning. TCF Live. It's Monday. But if you're going to have a Monday, this is the place to have it, because we can at least enjoy each other's company, watch some court, and let's face it, half of the people that we see today, they're having a lot worse Monday than we are. So, glass half full. All right, let's stay in Michigan. Go to Judge Elmore.
That are each entitled People of the State of Michigan versus Michael Davis Haines. The three case numbers are 26-14203, 204, and 205. That page. Appearances from counsel.
Nick Carnes on behalf of the people.
And good morning, Your Honor. For the record, Paul Tulland on behalf of Mr. Haines, present in the courtroom. I do consent to having my hearing, my presence by Zoom, as does Mr. Haines.
Mr. Haines, is that correct, sir? That you allow him to appear via Zoom?
Yes, Your Honor.
All right. Have you had time to speak with Mr. Tulland about the pre-sentence investigation reports? Right. Well, you haven't spoken to him at all about him?
I haven't seen him since last court.
Mr. Tlinda, have you gone over the PSIs here with Mr. Haines?
We did, Your Honor. We reviewed it. If I may, I believe that we did it on. We spoke on the 8th of June about. Was mailed to him on the 2nd of June.
I'm sorry?
The third.
The third? All right.
My PSI.
Oh.
Okay, hold on. Mr. Haines, maybe I can ask some questions better. You did receive a copy of the pre-sentence investigation report, is that correct?
Yes.
Okay. Now, you communicated, whether it's email, Zoom, letter, telephone.
Not since I got this.
Okay. All right.
I've only seen Mr.
Saladay?
Saladay, yes, sir.
All right. For the record, Mr. Stephen Saladay from the Department of Corrections is also here today. All right.
Your Honor, is it?
Sir?
Thank you, Your Honor. Would it be maybe logistically it's complicated? Is it possible to put Mr. Haines into a breakout room where I can speak with him privately?
No.
Okay.
I don't have a computer into a other room. The only way to do that.
Does the court, Mr. Haines, are you currently lodged in Grand Traverse County?
No, I'm in Westford.
Were you, okay, Your Honor,
All right, hold on, I've got it. We are adjourned. Find time to talk to your attorney, your client. We're done. Thank you. Mr. Haines, I'm sorry. You'll get some more credit. I can't do your sentencing unless your attorney does his job. Thank you. Don't send you back. It won't reflect negatively on you. Thank you.
Well, Judge Elmore's having a Monday right there. Wow. That's an unprepared attorney for sure. He didn't even know where his client was lodged. He thought his client was in Grand Traverse County. This is a Wexford County court. That's, yeah. You know, we've been doing this for over a year and a half now. That's one of the most unprepared attorneys I've seen yet. Interesting. They're having a Monday there. Let's go back to Judge Prill, new contestant.
7261, this time and date set for review of delayed sentence. The Defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Mikowski. An updated pre-sentence report has been prepared in this matter, dated May 20 of this year, prepared by Ms. Mandy Alexander. And Ms. Weisenbach, have you and your client had the opportunity to review the report?
Yes.
Any additions, deletions, corrections, or objections?
No, we didn't find anything.
Ms. Martin, you agree?
Yes.
Mr. Mikowski? Thank you. According to the report, back on June 30th of last year, defendant entered a plea to fleeing and eluding, and pursuant to the plea agreement, the court took this matter under the delay of sentence statute, imposed certain conditions, a number of conditions, special conditions including community service, and basically towing the line for a period of a year. And looks like we have a success story. Ms. Weisenbach, anything you'd like to say we have your client?
Yes. So Ms. Martin comes before the court, fines and costs paid, restitution paid, continued care and behavioral health, employed not just one job that's listed on here, 2 jobs. She's also picked up a house cleaning job. So with that being said, we also had a quick conversation with regards to expungement down the line. So that's it works. We're starting that clock, and she's going to do the medical deal. So that's going to be her goal, and she's still on track for that. With that being said, ask the court to follow the terms that were set up for the delayed sentence and enter this as an attempted police officer claim for it to agree. And we're done. Thank you.
You're welcome. Smart, anything you'd like to say?
I would just like to say I'd like to thank the court for giving me the opportunity to put myself back on track, and I appreciate everything that the courthouse has done for me, including you as the judge, giving me this opportunity. I really appreciate it. And it's really helped me along.
Thank you. Well, you also have to look at the prosecuting attorney's office as well, and your attorney to put all this together. There are certain cases once in a while where there are no plea offers, there's no discussion. It's either a plea or trial, but it depends upon the individual. Every case is different. And in this case, people, just a little while as your attorney worked on this together. And unless I hear Mr. Rakowski say that you failed miserably on the record, it looks like we have a success story. Mr. Rakowski, on behalf of you.
Your Honor, I would say to the court that this is what the court had spoken about in the last case, that, sentences are tailored to each case, and we look for individuals that, like for something like this, a delay of sentence, and the court's seen several delays that have not ended up, the way we wish it would. But Ms. Martin's done everything she's supposed to, so we agree. We ask you to adopt the recommendations that's set forth.
Thank you. I'm not going to delay it any further. You've done everything you were supposed to do. And hopefully you've learned from this as well. It appears you have. It definitely appears you have. And at the end of the day, like I said, Mr. Rakowski is exactly correct. Though you have to treat everyone the same. It doesn't matter who you are or where you come from. The point is, you look at an individual's history, you look upon the type of charge they're facing, and sentences have to be catered. Looking at all those factors, sentencing guidelines have to be looked at. You have no prior record at all. And as of today, you will have a record, but fortunately it's to a misdemeanor. And as Ms. Weisenbach stated, within the time frame here, upon successful completion of a period of time, you can come back before the court and maybe not even have this matter on your record at all. But let's see how it goes. But I congratulate you. You've done a great job. And not too often a court can do that. But I'm going to give credit where credit is due. And certainly you have toed the line, done everything. And we're impressed. Will be the sentence of this court that the conviction will enter as a misdemeanor attempt police officer, pleading will be 4th degree, and 94 days had been served, correct, Ms. Weisenbach?
There was a chunk, correct? It was part of the agreement.
And as a result, yeah, that was based upon the bond, correct? Is that based upon the bond?
I believe it was a forfeiture bonds.
It may have been. I don't have it up right now.
So 94 days jail, 94 days credit. You paid all the monetary obligations, but but I have to go through one final step. It's my duty to inform you, the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, court will assign counsel for your public expense. Conditional to receive the questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the Mercer court within 42 days. Good work. You're welcome. Good luck to you.
Alrighty, friends. Barbara, thank you for the $10. Let's make it a great Monday. After all, we're only watching court. Very true. We could be part of it. This is the better place to be. So thank you, Barbara. Appreciate that. Let's stay in Michigan. Let's say good morning to Judge Middleton, where he started his day quoting lyrics from Prince's Little Red Corvette.
And which case are you folks here on? What's your name?
Daniel Schrock.
What's your first name, sir?
Daniel.
Daniel Schrock. You're not, but we'll find it. Laura, we've got a Daniel Schrock here for arraignment. He's not on my docket, but he's here, so let's see what we can find out about it. Anyway, Miss Jacobs, would you come forward, please? Come right up to the podium right here, if you would. Mr. Houck, you get to watch a little bit of criminal court this morning, part of your legal education.
Thank you, Your Honor.
Good morning. This is file number 26890SM. People versus Lisa Schrock. Excuse me, Lisa Jacobs. Let's see what the deal is here. Good morning, Ms. Jacobs. It's alleged that you did willfully and maliciously destroy a camera and mount that belonged to Chase Deli, a resident or former resident of your household. That's interesting. That's a charge of malicious destruction of property. It's punishable by up to 93 days in jail and a fine of up to $500. You looked a little bit puzzled. You've never been here for this sort of thing before, but welcome to the historic courthouse. I know Mr. Deli. He's been here a few times on one matter or another. This is an odd sort of circumstance. This is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500 or 3 times the value of the property. How do you wish to plead to that charge?
No contest.
All right, well, let's talk about that. We've got a couple options. One is not guilty, which is, I think, probably what the public defender would recommend. Another one is guilty. When you plead no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. And I don't think that's really what you want to do. How did you and Mr. Deli come to live in the same home?
Mr. Deli is my son, my oldest.
Okay. Well, everybody's related to everybody else around here. I didn't connect Jacobs and Deli. As you know, Chase has had his issues.
And he still does, Your Honor.
All right, well, this alleged that you broke his $95 camera. I'm surprised they even charged this. He used a broom handle to knock it down. How did you, were you living in the same house?
My girlfriend was
Okay.
renting from him.
And he was living there also?
Yes, he was renting out the basement portion. It was an apartment underneath.
Okay.
His girlfriend owns.
Well, we had another one. This wasn't, we had an eviction case where
This
that's
is
the
the
one. He
same
was in
kind of
the,
issue.
well, that was a very, very nice home.
Very nice home is
Did-
right.
This was in January.
Mm-hmm.
So is he out now?
Yes.
All right, well, don't say any more because you just sort of, but, all right. So my recommendation, I guess at this point would be that you plead not guilty.
Okay.
And I think maybe I'll just set a pretrial with a prosecutor. This was in that house?
Yes. In Colon on that.
Yeah, I handled that case as the landlord tenant judge. And, as I recall, the house was being sold.
It already
You couldn't
did.
sell it with him in the basement.
Mm-hmm.
All right, I'm gonna set a pretrial. Did you get arrested on this?
No, I had to pay
This-
that bond though.
Well, this is weird. This happened in January. The trooper submitted it in May and my office issued it. Wow. My office, or the prosecutor authorized it in January. The state trooper didn't sign it. I'm gonna note this is related to that landlord tenant case. Oops. It wasn't in his name. What was it, in his girlfriend?
Yes, Mandy Hammond.
What's her name?
Amanda.
Amanda Hug and Kiss. You're Tina Hart. All right, that was 2-5. What do we find about Mr. Schrock? Okay. Yes. Please. He's also late. This case also requires prints, and we've got this policy where we don't have enough people here. and they don't print them. And so we got 6 people that need to get printed and nobody to do it. That's above your pay grade. I'm gonna take it up with the. Anyway, Ms. Jacobs, let's set this out a bit. It means you have to come back, and for that, I'm sorry, but I related it to the landlord-tenant case, and once they got the whole screen of it, maybe they'll. I wish Judge Pattison was here today, because then he could handle this, but he's not. Set this for Thursday, July 30th at 8:30. All right, I want you to come back. We'll get through the 4th of July and we'll get through July, and you can come back and explain your circumstance to the prosecutor and see what they want to do. If it can't be resolved, you could still ask for court-appointed counsel, or you could plead no contest. I'm not gonna try to get you fingerprinted here today, but you're free to go.
Good morning once again, everybody. TCF Live, episode 321 this morning. Good to have you all here with me. Let's head down to Florida. Wade Mercer, let's see how busy everybody got during this past weekend down there.
And that is Mr. Ricardo's here for Kelvin Armando. Good morning, Mr. Ricardo.
Good morning, Your Honor.
Good morning. Would you please introduce yourself to Mr. Armando and make sure that he can see and hear you?
Señor Armando, muy buenos días. Soy Jordani Ricardo, intérprete para que se comunique con el juez. ¿Usted me ve y me escucha? Sí. He can hear me and see me, Your Honor.
Thank you. Mr. Armando, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Armando, está aquí porque tiene un cargo de manejar sin licencia de conducir.
Es correcto.
Correct.
In addition to that, you have a hold from the United States Immigration Service.
Adicionalmente, usted tiene una orden de retención de parte del Servicio de Inmigración.
I have read the complaint and there is probable cause in the complaint.
He leído la denuncia y hay causa probable en la denuncia.
And I've also looked at your criminal history, which reflects no prior criminal history.
También he visto sus antecedentes penales, que refleja que usted no tiene antecedentes penales.
I am appointing the public defender's office to represent you this morning.
Le voy a asignar al abogado de oficio para que lo represente esta mañana.
And please listen to your attorney, Mr. McDaniel.
Por favor, escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Armando. We're going to hear a plea of no contest to the charges listed.
Su señoría, hablé con el señor Armando. Va a declararse no me opongo ante los cargos, tal y cual se le acusa.
Understanding he'll be sentenced to 4 days in the county jail, credit for 4 days, and a $400 fine, which would be a civil judgment that he does not have to pay.
Entendiendo que se le va a condenar a 4 días en la cárcel con crédito por 4 días, con una multa de $400, una multa civil que él no tiene que pagar.
He understands that any plea can be used against him in immigration court.
Él entiende que cualquier acuerdo en un caso penal se puede usar en el Tribunal de Inmigración.
Waived his right to jury trial and call witnesses.
Ha renunciado a un juicio con un jurado y a llamar a testigos.
Understands there's an ICE hold and ICE will pick him up within 48 hours or he'll be released.
Entiende que tiene una orden de retención de parte de Inmigración y que Inmigración o lo recoge en un plazo de 48 horas o si no, lo dejan salir.
Nothing else.
Thank you, Mr. McDaniel. Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
Gracias, señor McDaniel. Señor Mitchell, ¿está de acuerdo el Estado? ¿Lo está su señoría?
Mr. Armando, did you hear that agreement?
Señor Armando, ¿escuchó usted ese acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Sí.
Yes.
Okay, what is your question?
¿Cuál es su pregunta?
En caso de cumplir las 48 horas acá. Al salir, tengo que pagar los $400.
So if I were to stay for 48 hours in here, once I'm released, or if I'm released, do I have to pay the $400?
The $400 will be a civil judgment against you if you don't pay it.
Los $400 son un fallo civil en su contra si no lo paga.
What that means is that your future driving rights in Florida will be suspended until it's taken care of.
Eso significa que su derecho a conducir en la Florida o privilegio quedaría suspendido hasta que usted se encargue de eso.
And it may be sent to a collection agency to try to collect it.
Y puede que lo envíen a una agencia de colecciones para tratar de coleccionarlo.
But you cannot go to jail just because you don't pay it.
Pero no lo pueden llevar a la cárcel sencillamente por no pagarlo.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Sí, tengo otra.
I do have another one.
Okay.
Bien.
Según el acuerdo al que llegué con el abogado, las 48 horas de plazo comienzan desde hoy y vencen mañana.
So according to the plea that I reached with the attorney, the 48 hours, they start today and they're up tomorrow?
No, 48 hours means 48 hours.
No, 48 horas significa 48 horas.
It begins when you're released on the local charges, which is if you enter this plea, that's when you enter the plea.
Comienzan cuando usted acepte, cuando quede libre de los cargos locales. Eso sería en caso de que acepte el acuerdo, cuando lo acepte.
But 48 hours would not run until Wednesday morning.
Pero las 48 horas no terminan hasta el miércoles por la mañana.
Tomorrow would only be 24 hours.
Hasta mañana solamente serían 24 horas.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No, señor, y está todo claro.
No, Your Honor, everything is clear.
Is that the plea you would like to enter then?
¿Es este el acuerdo que desea aceptar?
Sí.
Yes.
Mr. Armando, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Armando, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to judge you guilty and sentence you to 4 days, and excuse me, just a second, with no prior history. Is there any objection to withhold?
No objection.
Bien, siendo que no tiene antecedentes penales, ¿hay alguna objeción a que se le suspenda el fallo de culpabilidad? No, no hay ninguna objeción.
So I'm going to withhold adjudication of guilt, which means you don't have a conviction for this offense.
Le voy a suspender el fallo de culpabilidad, así que no le va a quedar una condena por esta ofensa.
I'm going to sentence you to 4 days in jail with give you credit for 4 days you've already served.
Lo voy a condenar a 4 días en la cárcel, pero le doy crédito por los 4 días que ya cumplió.
Court costs and fines are imposed in the amount of $400, and that'll be a civil judgment against you.
Se le imponen multas y costas por $400, pero serán un fallo civil en su contra.
So you have resolved the local charge, and the Immigration Service will be notified today to pick you up.
Así que ha resuelto los cargos locales y se le notificará al Servicio de Inmigración hoy para que lo recojan.
Mr. Armando, do you have any questions?
¿Alguna pregunta, señor Armando?
No tengo ninguna.
No, I have none.
Have a good day, sir.
Que tenga buen día, señor.
Muchas gracias.
Thank you very much.
Gracias, señor Ricardo.
Thank you, Your Honor.
All right, ladies and gentlemen, let's go back to the top of our docket. Only have a couple more cases. Denavius Sampson. Mr. Sampson, good morning. Mr. Sampson, you're here because you've been accused of one count of felon in possession of a firearm. Mr. Sampson, there is probable cause in the complaint. I looked at your criminal history with this, which is lengthy but old. And when I say old, I don't see anything in at least the last 15 years or so. Do you know how long it's been since you've been charged with a crime, Mr. Sampson?
I think by 09.
Okay. The other thing that's relevant for bond purposes, Mr. Sampson, is your sheet, your first appearance sheet reflects that you have had the same job for about 10 years. Is that right?
Yes, sir.
Where's that at?
Giggly Enterprise, Panama City.
What is Giggly Enterprise? What do they do?
Packing, receive material, like filters, all filters and stuff. They get
And in
painted.
addition, I'm sorry, go ahead. I didn't mean to interrupt you.
They get painted a certain way and shipped off.
Okay. In addition to that, you have a lawn care service?
Yes, sir.
Okay. So you got Mr. Mitchell and Mr. McDaniel. So the firearm was allegedly found in his home, the shotgun under the bed, supposedly for protection purposes only. It's not like he was out using it to commit a crime, but it does appear there's evidence he's a convicted felon, had the same job for at least 10 years and not been in trouble for about 15. Mr. McDaniel, anything else I need to be aware of?
Just, that you can see it's probably not something just happened yesterday. It was all because of a complaint that come in and someone trying to get after him, it looks like.
Okay. Thank you, Mr. Mitchell.
Nothing at this time, Your Honor.
Mr. Sampson, I'm not going to give you a conditional release on a second degree felony, but I'm not going to set you the normal bond I would set. For felon possession of a firearm, normally I would set a second degree felony bond. But your situation is very unique based upon your employment status, how long you had the same job, how long it's been since you've been in trouble, as well as the type of firearm, and if you had it riding around in your vehicle, or certainly if you're using it to commit a crime, that changes everything totally. But it's not your normal felon possession of firearm case. It's a constructive possession case. Constructive possession means it wasn't in your hand or on your person. It was somewhere else that you allegedly had control over. So I'm going to set you a bond. If I set you a $5,000 bond, that means you'd have to pay $500 to a bondsman. Can you post that bond, Mr. Sampson?
If I can make 2 phone calls, yes, sir.
Okay. Mr. Mitchell, I'm thinking about setting a third degree felony bond based upon the reasons I've already put on the record. What's the state's position?
No objection to that.
I'm going to set a $5,000 bond, cash or surety. You can go through a bondsman. You'll use the phone in just a few minutes, Mr. Sampson. If you go through a bondsman, they're going to charge you somewhere around $500 to post the bond. If you put up all $5,000, that's okay too. You can do that if you wish, and if you do that, you would get all $5,000 back if the case is dismissed. If it's not dismissed and there's court costs and fines imposed, they come out of the bond. Mr. Sampson, you get to use the phone in a few minutes. The jail's also going to give you a notice for your court date, Mr. Sampson. They will not give you won't get anything in the mail. They're going to put one in your hand, and that court date will be July 7th at 8:30 a.m. will be your court date in the circuit court before Judge Garcia. Mr. Sampson, do you have any questions?
No, sir.
Okay, let me clarify one thing. The complaint says the firearm was not seized as evidence. They photographed it, I think, instead. So, Mr. Sampson, if you're going back to the home where this firearm is at, you cannot have access to it. I don't want you getting out and then you getting charged with power of access to the firearm. If you're a convicted felon, you can't have access to firearms. Access means it can be in the home, or if it's in the home, it's got to be in a place you don't have access to, like a locked gun cabinet that you don't have a key to. So
Yes,
you
sir.
cannot have access to that firearm. Make sure you don't get yourself in a bad situation by going back to that same home and still allegedly having access. Okay.
Mr. Sampson, remember why you got arrested now when you go home, because, you're liable to get arrested tomorrow for something else, domestic violence or something, I don't know. So just remember why you got arrested. So you might want to go somewhere else.
Yes, sir.
All right. Have a good day, sir. And we have Kenneth Collier.
When's that is today for the felony thing?
Mr. Collier, good morning. Mr. Collier, you're here because you've been accused of violating the terms of your conditional release in case 26322 MM. Mr. Collier, the allegation is you were granted a conditional release, and the same day you got out of jail, you went back to the residence. You were ordered to not go within 100 feet of. Supposedly it was captured on video. I'm going to listen to the attorneys and I'll make a bond or a release decision. Mr. McDaniel, anything?
Your Honor, I emailed Mr. Ramey, his attorney, so that I suspect you're going to hold him anyway. The complaint sounds pretty straightforward, but I don't think he had any criminal history, very little criminal history, and he's obviously injured, and it is what it is. We were supposed to be 100 feet, if I recall, away from the house. I don't know how close he was. The video. So
according to the video, it's at the doorbell.
At the doorbell. So, and Madam Clerk, after he filed a notice of appearance, they put him on the wrong arraignment date. So we want to change it to the attorney date.
Thank you. Mr. Mitchell, I didn't realize he had a private attorney.
I didn't
so-
either until today.
So we need to deal with it when his attorney's here. What I typically do in these kind of cases, Mr. Collier, is I'm going to hold you until Friday. I'm going to bring you back up the first appearance Friday, and in all likelihood, I'm going to consider some type of bond, but you're not going to be allowed to go back to that property at all. I tried to be flexible and let you go to the property, live in a camper on the property. So you've got between now and Friday to try to find other options, but the complaint alleges that there's a video of you clearly violating the court order the same day you got out of jail. And that's very concerning to me, but I'll see you at first appearance again Friday. If you talk to your attorney, if he or she's able to make it to first appearance by video, that's fine. If not, I'm still going to consider some type of bond option on Friday and see what the state's position is. Thank you, Mr. Goods. Mr. Goods is reminding me, and Sergeant was about to remind me, Friday is a court day, a holiday. That's good. We get 1 or 2 of those a year. It's always nice to have those. So I'll see you Thursday instead, okay?
Yes, sir.
Mr. Collier, you did hire Mr. Ramey, didn't you? Russ Ramey to represent you, or is that a mistake I saw in there?
No,
Okay.
that's true.
Oh, okay. I thought you had like.
I'll see you by video Thursday, and most likely I'm going to set you a bond, but I'm going to listen to the state's position before I do so, okay?
Okay. Thank you, Your Honor.
All right. Yes, sir. See you Thursday. All right. So that was Mr. Collier. Then we have Stetson Phillips. Who's the quarterback for Georgia? Stetson Bennett. Mr. Phillips, good morning. Mr. Phillips, you have a fugitive warrant out of DeKalb County, Georgia. Mr. Phillips, you're being brought up to see if you want to waive extradition or not. I know that you talked to Mr. McDaniel about that process. And Mr. Phillips, do you have any questions?
Is that all right?
Mr. Phillips, listen to me, not Sergeant right now. Mr. Phillips, do you have any questions about the waiver of extradition process?
I was gonna say, can they, cause I never got,
Mr. Phillips, I told you before, really ain't the time to making statements about it and stuff. And I mean, it's just gonna be a waiver to waive your right to go ahead and go to Georgia, or you not waive your right.
The issue today is whether you want to contest their right to come and get you. They have to prove that you're the same Stetson Phillips that they're accused of a crime. They do not have to prove that you're guilty of the crime at this point. They just got to prove that you're the same one that's been accused. So if you waive extradition, and you do that in front of me, they have 30 days to pick you up. If they don't waive it, they may get longer than that because they have to go through a governor's warrant process. And they can have up to 90 days potentially. Do you have any questions about that process?
No.
And you do want to waive extradition, is that right?
Yeah.
Mr. McDaniel is satisfied he's doing this freely and voluntarily?
I am, Your Honor.
So, Mr. Phillips, I'll wait till you get through. They have 30 days to pick you up, Mr. Phillips. That 30 days starts today, but we review the cases at 15 days. We ask them to pick you up within 15 days. Where was this at? It was in Georgia. Decatur County. They're probably going to get you within 15 days. If they don't, you come back to first appearance. I'll say, Sergeant, what's going on with the transport? What update have you have? And you'll get to hear the answer just like me, and you'll get an understanding of what their plan is. You cannot be held longer than 30 days from today under any circumstances. On the 31st day, you're released, period. But that's very, very rare. The vast majority of the time, they'll pick you up, hopefully even within 15 days. But if you're still here, I'll see you then to get an update. You have any questions?
Yeah.
Okay, go ahead.
Cause I was gonna say, I never got to get a warrant. I never got a court date. I never got the court date in the mail. So if it was
depending on some warrants, you don't get a court date. Some warrants, they just issue a warrant. That's very common in Florida. I have no idea about Georgia. So I can't tell you. Once you get up there, you'll find out more detail. I have no idea. When you get up there, you'll find out, was there a notice mailed? If so, what address was it sent to? You can find all that out when you get there. But a lot of times, the majority of the time in Florida, there isn't a notice sent. When a warrant's signed, officers come looking for you. So you'll find that out when you get there, okay?
All right, thank you.
Have a good day, sir. Sergeant, I think that's it for my list. Anything else from the jail this morning?
Actually, fairly short and calm morning for Wade Mercer. I'd expect him to be busier on a Monday. Good morning once again, everybody. Episode 321 of TCF Live here. We've got Lone Wolf in the chat this morning. Good morning to you. If you are not familiar, he runs a great Courtroom channel as well. So when you're not watching TCF, if you're looking for something and you're not already familiar with Lone Wolf, go check him out. Let's go to Texas. Judge West, the Monday Morning Fashion Show, starting off with suspenders.
Initial appearance in cause number 26 DCCR 0904. Just a second. You're charged with the state jail felony offense of forgery of a financial instrument from January 29th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Not yet.
So what I'm going to do, sir, is reset your case about 30 days to give you some time to try to hire someone.
Yes.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you that reset. Sign right here. Paul Malone. Paul Malone. Paul Malone. Okay. All the way up. Good morning. You're Paul Malone?
Yes, ma'am.
And Mr. Malone, this is cause number 20-34762. And it looks like you have a motion to revoke your probation on probation for unlawful possession of a firearm by a felon. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, but I can't afford a lawyer.
Well, how did you afford that bond?
My mom paid 1,000. I'm paying off 100 every 2 weeks.
Are you working?
Yes, ma'am.
Okay, so what I'm going to do is reset your case to give you some time to try to hire someone. So if you get someone hired before that next court date, you just need to bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Let me look at something real quick. So as a condition of your probation, obviously, look. Where are you living?
I was at the behind Tammy's at RV, but my air conditioner broke, and now I'm staying with a friend at the apartments. But I told my PO was out there.
You did?
Yes.
And you've got that GPS monitoring device?
Yes, ma'am. I was wondering if I could get it off because I can't really afford it.
Nope. That was a condition. That's one of the few things that made me comfortable setting the bond in your case back when I set it. So that's staying on so that I know for certain and I'm comfortable that you're not going anywhere that you're not supposed to be. All right. So I need you to try to get a lawyer if you can before that next court date. And then we'll see where we are. Okay. Make sure you bring the names of who you've talked to if you don't hire one.
Yes.
All right. Step in front of the clerk. Hannah Ballard. No. Good morning. Are you Hannah Ballard? Yes. And Ms. Ballard, were you able to get someone hired? Who'd you talk to?
Rife F. Kemmler, Rife S. Kemmler, and Winston Scott Adams.
Okay.
And was going to see if I could get Mr. Kemmler hired, but he told me to come back to his office for us to talk about price, because he didn't give me the price that day I got his card. Because he was in another meeting with someone.
Okay, so but you've had a whole month to try to do that, so you can't wait till the last week to try to go see a lawyer because they're busy. You've got to go as soon as we're done with your with your court date. Is that all? You just talked to two, not three?
And Philip Dowden, I didn't get a card from him.
But you did talk to him as well. All right, so Ms. Ballard, I'm going to reset your case one more time. Don't wait till that last week. Go visit with Mr. Kimmler. If you get him hired, great. Bring the reset notice to him. If for some reason that's not going to work, talk to at least 3 more. Bring me those names and then we'll discuss your options. Okay?
And my employment, I don't want to, without telling you, I'm no longer employed at Dollar Tree because I had a situation with allergic reactions. But I did still do what you told me to do, and I was applying to every jobs that I could.
Okay.
And I got an interview at Cascades Nursing Home for next month on the 6th.
You do? Okay. All right. So you're not working at Dollar Tree anymore. So let's do this, Ms. Ballard. I'm going to have you fill out some paperwork this morning to see if you qualify for employer. You need to fill it out accurately and completely. Don't just leave it all blank. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. You step in front of the clerk on the end, she'll give you that paperwork. Pagan Downhour. Pagan Downhour. Sure.
Pagan. Or does the shake them basement out there?
Does she? You just know, I mean, that's just how it's spelled.
Yeah. No response, Sean?
Right, bond will be forfeited for non-appearance and reset at 100,000. Rodney Hines. Good morning, sir. Are you Rodney Hines?
Yes, ma'am.
And Mr. Hines, did you get someone hired?
No, ma'am. I talked to a few lawyers, because of my background, they want significant amount of money.
Who'd you talk to?
Talked to, Brittany Holmes, Ryan Gertz, Corey Crenshaw, talked to right from secretary. I'll probably go meet her when I leave. They just wanted to have money down because of my background. But they knew she would be high.
And where are you working?
I got was working at the port. I got another interview at AWP, safe when I leave.
So you not working at the port right now?
No.
Why not?
But they was at a job in Corpus and I couldn't go a couple of months.
If I test you this morning, you gonna have anything in your system? Let's double check that and then we'll talk about your options. Have a seat in the jury box.
Often imitated. Let's try that again. Learn how to speak, Dan. Often imitated, never duplicated. Almost got it out there. It's TCF Live on a Monday where we're still learning how to speak. Okie dokie. Yeah, we'll keep an eye on Judge West's court. Not a whole lot surprising on the Monday morning fashion show, but it still amazes me how many people wear their yellow safety vests into court. It's like a thing. Let's do this. Let's go back to Judge Prill, new contestant there.
People, State of Michigan versus Bretton Lee Wright, file number 26-7471 FH, time of day set for arraignment. The defendant is present, represented by Attorney Elizabeth Weisenbach. People are represented by prosecuting attorney Timothy J. Rakowski. Ms. Weisenbach, have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity, that is, to review it, and you waive the reading as well?
Yes.
And as stated off the record, this is the officer, is that correct?
Yes.
Right, please raise your hand.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do. Mr. Rutkowski, would you please state the terms of the plea offer on the record?
Yes, Your Honor. Mr. Wright would be pleading guilty to the charge. People agree to a 1-year delay of sentence. If Mr. Wright completes all the terms of the delay, the conviction would enter as attempt resisting obstructing, and Mr. Wright agrees to revoke his bond for 45 days during the course of the delay.
Ms. Weisenbach, is that your understanding?
It is.
Mr. Wright, is that your understanding of the plea offer?
Yes, sir.
And you wish to accept it?
Yes, sir.
Are there any other terms to the plea offer that we've not covered on this record?
Not that I'm aware of.
Thank you. Ms. Weisenbach?
Agreed.
Mr. Rutkowski?
Yes, Your Honor.
Mr. Wright, are you on any term of probation or parole?
No, Your Honor.
Have you had sufficient time to speak to Ms. Weisenbach about this?
Yes.
Do you need any additional time to speak?
Not at this moment.
Anything affecting your mind or brain making it difficult to make important decisions?
Yes. No, Your Honor.
Okay. You have a clear mind?
Yes, sir.
You're charged with resisting or obstructing a police officer. That is a felony. Carries a maximum prison sentence of up to 2 years and or a fine of up to $2,000. You understand the charge and maximum sentence may be imposed. Understanding that, then, sir, how do you plead to that charge on or about March 23rd of this year in Colfax Township, Huron County, Michigan? Ms. Weisenbach provided the court with an advice of rights form, and you signed this document, sir?
Yes, sir.
Before signing it, you read over this document?
Yes, sir.
You also went over it with Ms. Weisenbach?
As well. Yes, sir.
You understand the rights contained on the form?
I do.
By pleading guilty, you're giving up those rights.
I
You understand that by pleading guilty, you will not have a trial of any kind, nor have any opportunity whatsoever to contest your guilt, and all that remains after today will be for you to consent.
Yes, sir.
If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed in this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you to plead guilty in this matter? You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Does anyone promise the court will be easy on you? Does anyone threaten you to enter this court together? Be your own free choice?
Yes, sir.
Court costs are due and payable at time of sentencing unless there's good cause shown. Do you understand that? And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand that, sir?
Yes, Your Honor.
Mr. Ray, any question regarding any of your rights? All right. Any questions again of Ms. Weisenbach? Back on March 23rd of this year, were you in Colfax Township, Huron County, Michigan?
Yes, sir.
And did you make contact with a police officer?
Yes, sir.
And was that Deputy Sheriff Austin Ballmer?
I don't recall the name exactly, but that's what the record shows.
All right. And what makes you believe that you're guilty of resisting or obstructing or injuring Deputy Ballmer on that?
Well, I was being transferred to the hospital. I got out and I ran.
Okay, so you were under Deputy Ballmer's custody at that point?
I'm sorry.
You were in his custody at that point?
Yes, I was in the custody of the jail. Yes.
Okay, and you left or you attempted to leave without the consent of the deputy?
Yes, sir.
And was this deputy in full uniform, merely doing his job?
Yes, sir.
Any objection, Ms. Weisbach, to the factual basis?
No.
Mr. Rutkowski?
No, Your Honor.
Mr. Rutkowski, you aware of any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Ms. Weisbach?
No.
Has the court complied with the court rule concerning the plea, Mr. Rutkowski?
The court has.
Ms. Weisbach?
Agreed.
Mr. Wright, there's no agreement made by this court concerning the plea when the final sentence will be. Is that accurate?
Yes, sir.
Ms. Weisbach?
Yes.
Mr. Rutkowski?
Yes, Your Honor.
Court will accept the plea. Is that agreement? It's voluntary, it's understanding and accurate. There's a sufficient factual basis. And we'll schedule a sentencing date for August 31. I believe it's 5 o'clock. You're over here. August 31, 2026 at 9 a.m. prior to sentencing. Court is ordering a pre-sentence investigation report to be prepared by both counsel and court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing by the counsel. Any objection to the scoring of the guidelines filed in writing with the court no later than 7 days from sentencing. The writing is prepared the court at the time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response is filed 3 days thereafter. $3,500 10% bond is posted in this matter. Mr. Burkowski, any objection to the bond?
No objection, Your Honor.
Thank you. Ms. Wise about comment.
Ask the court to continue, Bond.
And it shall continue.
Thank you.
Right, we'll see you then on August 31st. You ought to meet with the probation agent here momentarily. Follow through with all that, and we will see you then on the end of August.
Thank you for your time, Ron.
Thank you.
Hour 2 of TCF Live here on this fine, fine Monday where the sun is shining and the birds are chirping and they're happy, probably because we're not going to be 117 degrees today in the desert, so they might actually survive. Let's do this. Let's go back to Judge West. Somebody is approaching that is proper representation for her Monday morning fashion show.
Morning. Are you Pagan Downhour? Ms. Downhour, it's very important that you're here on time. I forfeited your bond and reset it at $100,000 because you weren't here. I'm going
Here, I'm so I've been here since 8 this morning.
Well, they called your name.
I was in those doors asking which courthouse I was supposed to be in.
Okay. I'll recall the bond forfeiture. And so, Ms. Downhour, this is your initial appearance in cause number 26 VCCR 0906. You're charged with a second-degree felony offensive assault on a peace officer, and that's from March 20th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I asked for one to be appointed.
So when you're in custody, we automatically grant that and give you an attorney. But once you make bond, I'm going to expect you to at least try to hire your own attorney. So what I'll do is reset your case for about 30 days to give you some time to try to get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? Give me just a second to take a quick look at something. All right, step in front of the clerk. She'll give you a reset notice.
Thank you.
All right, friends, we'll keep an eye there. Let's do this. Let's march across the hallway. Say good morning to Judge Stevens.
She's here. What are you doing? Well, then I'll just dismiss it. If that's the deal, right? Yes. What's the number? Which one are you doing? The DWI or the theft?
You're putting on the DWI.
I got the DWI.
Yes.
The theft is going to be dismissed.
I got to run concurrent. They pled to run concurrent. If you're
to vote for your judge.
It's not on the front of the file.
Yeah, because she like.
Oh, it's reset for the sentencing.
Yeah. Yeah, she did plead the vote. That's correct. I had the DWI 6.
Yeah.
All right.
Did you want to look at this to refresh your memory here?
Okay.
2 minutes ago, you weren't. All right, guys.
Spin all this stuff together.
6 years. Right? Yes, sir. It is. It's one of all cases. You want to send me.
Yeah.
Yes. That's what she is.
Two cases are called, Jessica Kelvin, right, that's you, present, with Mr. Adams and Mr. Kennedy. You have two attorneys. I may just dismiss these cases. That's got to be enough punishment, you two, for this proposal.
Well, you would accept that offer. Let's see.
Talking about dismissing her and then charging you all. I don't think we've done a plea on the DWI. It looks like we've got a plea done on 622 on the theft, but not on the DWI.
That's Mr. Larson.
Shall we do? No, shall we do both?
Well, it's, see, I didn't put, there's nothing on the front of it, and I normally, it's a DWI third, right? Yes, sir. Well, I would have done something on the second paragraph. I always did when I did.
I never been in board for the DWI.
Okay. No, we can do it today. That's fine.
Hold on.
Good to get her. Okay. I signed up for it. I'm not signing up.
I have copies of plea papers on that same day on this case.
Y'all positive, he said those.
Yeah. It just didn't get based on the file. In 23 CR 757. Reset for 775. Earlier in this case on 6/22/26. The defendant signed plea documents in this case. And pleaded guilty to paragraph state jail felony of theft with two or more theft prior convictions. And then paragraphs 3, I'm sorry, 2, and then 3 and 4 were prior convictions of state jail felonies on the same date, April 10th, 2001, out of this criminal district court, which means this is a state jail felony punished as though it were a third degree felony, like the plea papers state. Ms. Wright, are you continuing to assert your plea of guilty to this theft case, the state jail felony, and plea of true to the prior 2 or more theft convictions in paragraph 2, and admit to the state jail felony of forgeries on April 10th, 2001 out of this court, which constitute what state jail felony punished as though it were a third degree felony?
Yes, sir.
The state's exhibit 1 had been admitted at that hearing, reflecting all the acknowledgements and agreements signed by the defendant and the defendant's attorney and the state, and that the agreement is that then it would be sentenced to 6 years in prison, and that would run concurrently with 25 CR 928. Is all of that true and correct?
Yes, sir.
Anything else to add on this case? Was there any restitution on this? I didn't. Oh, was there any restitution? Was there a loss here, man? Do you remember?
No.
They got whatever it was back, or they did.
Apparently already in the misdemeanor. I went to community service for like 107 hours. So.
It says clothes of a value of less than $2,500 is what these. All right, if nothing further on this, I'm going to find that you have pleaded guilty to paragraphs 1, 2, 3, and 4, which constitute a state jail felony punished as though it were a third-degree felony. There was sufficient evidence supporting your guilty plea as you entered your guilty plea in on those paragraphs to constitute this state jail felony, punished as though it were a third-degree felony. States Exhibit 1 was admitted into evidence earlier on June 22nd, 2026. And the agreement is the defendant will be sentenced to 6 years in prison. I now, if nothing further, I now find that you have pleaded guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. Punished though as though it were a third-degree felony, as paragraphs 1, 2, 3, and 4 are all proven true beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 6 years on that case. In 25 CR 928, this is Mr. Adams' case, and you have signed States Exhibit 1 documents here, although the court did not go over those documents and place those documents or the understanding of those documents in this indictment for some reason, which I always do. I guess something must have been stalled and she needed additional time or something, didn't you? You wanted additional time for sentencing, so we stopped everything and brought you back today. All right. In 25 CR 928 on this operating a motor vehicle in a public place while intoxicated on or about December 2nd, 2024 in Jefferson County, Texas. Are you guilty of that beyond a reasonable doubt?
Yes.
You're pleading guilty and reaffirming that from this June 22nd hearing where you entered plea of guilty in that case. And this is States Exhibit 1 that was admitted, which states you are mentally competent to enter your guilty plea and it's freely and voluntarily made, and you are guilty of this offense. And then paragraph 2, which alleges the 2 prior, actually it's 2 or more, it's 3 prior DWI convictions in 2007 out of County Court of Law number 2 of Orange County, Texas, and 2 DWIs on October 4th, 2012 out of County Court of Law number 3 of Jefferson County, Texas. Are those allegations of prior operating motor vehicles while in a public place convictions true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct with those voluntarily and because they are true?
Yes, sir.
And you reaffirming your plea of guilty in paragraph 1 on or about December 2nd, 2024 in Jefferson County, Texas. You operated a motor vehicle in a public place while intoxicated. Is that all true and correct? Or are you pleading guilty, reaffirming your plea of guilty to that that you made earlier on June 22nd this year.
Yes, yes, sir.
And are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
All right. Pre-sentence reports are all ordered in each of these cases. In this case, I'm going to find you have pleaded guilty to paragraph 1 and true to paragraph 2, constituting a third-degree felony of operating a motor vehicle in a public place while intoxicated, a third-degree felony. You were doing that voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted earlier to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt, and I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to service term of 6 years. These 2 sentences shall run concurrently. Do you understand what's happened today? I good luck to you. Thank you.
Thank you, Judge.
Yes, sir.
Good morning once again, everybody. It's TCF Live on a Monday, episode 321, I believe. Very cool. If you're new out there, do us a favor if you haven't already. Say good morning in the chat. We're friendly folk. Engage us. You'll love us. Let's do this for a quick second until the next contestant comes up. If you'll recall, last year during the summertime, we were watching bears at Brooks Falls up in Alaska. The bears are back. So let's just stare at the bears for a moment. Good, relaxing kind of palate cleanser between the chaos of court. It's good that they turn the feed back on. Just waiting for some food to swim by. All right, we'll keep an eye. Let's go back to Stevens, new contestant coming up.
All right, we're from 26 CR 962. You're James Rodney Goodman.
Yes.
Correct. And you were here with your attorney, Mr. Brantley, the state's attorney. You were charged in this case with aggravated assault, causing serious bodily injury by shooting the complainant with a firearm in this indictment. That is a second-degree felony, which carries with it up to 20 years in prison. Your criminal history is rich, and it goes back to 1987. It looks like 2 convictions of illegal possession of controlled substances out of 252nd District Court in 1987. After that, those became final. Paragraph 3 goes on to state you committed another felony of illegal possession of controlled substance and was found guilty of that in 1990 in this court, criminal district court. After that was final, you committed the offense of illegal possession of a controlled substance, a third-degree felony in 2007, and were finally convicted of that. That was
Yes, it's still.
so you were a habitual criminal 2 convictions ago. So your bond is $250,000, and the circumstances here is that police on Friday, April 10th this year, were dispatched to Swift gas station 4705 Magnolia here in Beaumont, Jefferson County. Observed a black male laying on the sidewalk who had been shot. And police reviewed the store surveillance camera, showing you shoot him. And you were detained and they found you in the area and you were Mirandized and agreed to speak to officers and admitted to shooting Caesar. And you were then placed under arrest for aggravated assault. And when they searched you, was that cocaine found on this one?
That's what it appears like, Judge. I'm checking,
Yeah.
I don't see where we got.
And 2 firearms. You're a convicted felon already. As you know, you're unable to possess a firearm. It's not only a state crime, it's a federal crime as well. All right. It's a part of the bond is a go ahead.
If I may, this happened or occurred at his residence. There's a question of whether or not he can have a firearm or not with reference to the possession on the state side. I understand the federal side. The instrument that was used, that he admitted to was a BB gun. Yes. And when they found the complainant on the, in front of the convenience store, he was too intoxicated or high, to even communicate. So they brought him to the hospital at that time. This had to do with an incident that
the defendant.
Quick pause because I feel a potential run coming here and I don't want to fall behind. Wahoo, thank you for gifting a membership. Cascadia, thank you for gifting a membership. And Lindsay, 10 gifted memberships. Thank you. I appreciate all of you. Seriously, the support you guys always show me. I hope you realize it never, ever goes unnoticed and unappreciated. So thank you so much.
You're talking to the victim.
The victim
I thought you said the defendant.
was already done. The victim was out in front of, was in front of the convenience store. You know, it was a termination that he was too intoxicated or high at the time. I questioned the indictment in reference to a firearm. I don't believe a BB gun constitutes a firearm, though a BB gun could be a deadly weapon. It's not alleged that way. I'd ask that that the bond be lowered. One, because it was on the house. There was a complication between the complainant and Mr. Goodman, and he would not leave, and he was threatening him. And I know those are matters for trial, but we would ask that the bond be reasonable in light of these circumstances. And I believe possibly controlled substances were when they went inside the house, and not on his person.
Anything else? For you,
Oh, Judge, I think we've got a good grasp, but I would tell you that the reports don't state a BB gun. They do mention a pellet rifle. But the state feels that the specifically based upon his admissions and his criminal record that the county can only be safe if the bond continues at the amount that it's set. Yeah.
Well, yeah, you're right. He's sitting on his front porch in his own house minding his own business. That's where it occurred. It didn't occur in the parking lot of
That's just not what the probable cause affidavit states.
Well, that's where he was.
The bond, the court feels that this bond is appropriate under these circumstances in your rich criminal history.
We'd ask it in place on the trial.
It's going to be set for trial. Okay. All right. Let's see.
Ashley, thank you for gifting 5 memberships. Appreciate you as well, always. Seriously, the support you guys show me in the community, it's amazing. So thank you so much. Let's go back across the hall, see what's going on with Judge West.
Jr. And this is 26 DCCR 0516. Mr. McCoy is charged with driving while intoxicated, third or more. And what is the announcement?
We would ask for a reset, Your Honor. We have a couple of discovery issue that should be resolved very quickly, but also there's some other.
Judge, he's gotten video discovery for some reason, and I think it was just an error. He didn't get added on paper discovery. We need to fix that. Plus, Mr. McCoy has at least 3 lab reports that are pending completion, both from this offense state and in different offense states.
Okay. And so is there another offense potentially coming, or is that not going to be?
They all 3 are suspected cocaine, so I'd expect at least 1 or 2 new cases to be coming.
All right. So let's just do, I'm going to do about 45 days, see where we are. If you can get with, obviously, the quicker the lab can get that done, that would be great. And then we'll see where we are at that time. Stay in touch with Mr. Jeffries. He'll let you know when you need to be.
Does he have, what kind of device has he been ordered to have here?
Well, I would think that Mr. Jeffries would have to, Mr. McCoy. Are you wearing, do you have the auto ignition interlock device? You have the patch as well.
Patch is my concern. So as long as he has a patch and it's not been reported.
Have you, let me look at something real quick. That patch was a condition of your bondsman or of your bond when you left jail. The magistrate told you that, or your bondsman told you about the patch?
In jail.
Okay. And so when did you get out of jail? How many times have you switched out that patch?
I haven't yet, because I went to a inpatient program. So.
Okay. So
Monday is my first time.
So here's the thing, if you wear it longer than you're supposed to, it's not testable.
Right. It's I go next Monday coming is when I
You're 2 weeks. Okay. All right, perfect. All right. Make sure, obviously, if that shows positive, I get those results now that that's ordered. If it shows positive, your bond's going to get raised and you'll be back in custody. So do whatever you need to make sure you're on time getting them changed and that they're testable every time. Okay. Anything else?
No.
All right. You're free to go. Stay in touch with Mr. Jeffries. He'll let you know when you need to be back. Thank you.
Thank you, Your Honor.
Morning, Mr. Nichols.
Good morning.
Mr. Johnson. He must be walked outside. Mr. Lewis, looks like you're working on some paperwork.
Yes, ma'am, for
Okay.
Mr. Killer.
Okay, I'll hold your other one while you're doing that, and then we'll take care of both of them. It's Charlie, Mr. Rojas. This is a little docket.
Alrighty, friends, let's go back up to Michigan. Judge Elmore checking their new contestant.
All right, we are back on the record today for the 28th Circuit Court. And the next file today is People of the State of Michigan versus John. File number is 26-14221-F8. Appearances, please.
Nick Harms on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Huntley. Mr. Huntley appears on the Zoom. I'm sorry about the confusion this morning, Your Honor.
That's all right. Mr. Huntley, are you able to see and hear the court, sir?
I am, Your Honor.
Thank you. Also before the court this morning is Mr. Stephen Salad. He's the agent from the Michigan Department of Corrections who has helped prepare today's pre-sentence investigation report. We are here today for a sentencing on this case in which there was a conviction entered and accepted on the record on May 22nd for a conviction of possession of methamphetamine. The defendant is currently in a treatment program. Is that correct, Mr. Harrison?
Yes, he entered that program on June 16th. I would request a brief adjournment of the sentencing to allow him to have at least the initial 30-day period under his belt. Perhaps we could reassess at that point.
All right. I think that's probably fair, Mr. Carnes. Do the people agree?
Your Honor, I don't object to that.
All right, thank you. One moment here as I make a note.
We really appreciate this accommodation, Your Honor.
Yes,
He
I
did a
do.
lot of legwork. He did a lot of legwork to get himself into the program, and I'd like him to focus on that.
I want to see him do the same. One moment. I'm going to have it reset for sentencing in about another month. That allows him to complete the program. If there's any failure where he leaves the program or is discharged unsuccessfully, or anticipates that to find out through community corrections. All right, Mr. Huntley, you have a 5 to 23 guideline range. That's what we call a straddle cell. Straddle meaning it's balancing between jail or prison. Now, I'm not making a threat. I'm not making any promises. Since we did not go through the PSI very thoroughly, what I'm going to, what happens here is how well you have performed on bond and probation in the past and how well you handle this is important to the court. Wink, wink. Nod. Okay. All
yes.
right.
Oh, sorry. Sorry, I didn't mean to interrupt. Is it all right if I speak? All right. The date that I entered here was the 19th, and if they allow me to do 45 days, because I'm trying to put a 100% effort in that, is that something that you guys would allow, or?
Yes, sir. That's why I'm setting it out at least 45 days. And if we have an issue, you're still in the program, or even if you continue into a sober living portion.
Yep, I signed up for that this weekend, so.
All right, so if that's what happens, you make sure you let Mr. Harrison know. And then if you're still in that sober living facility, I'll extend sentencing out even further if the parties both agree. We want to allow you to maximize the benefit of that programming. All right, sir?
Thank you, sir. I really appreciate the offer and the help here. I've been trying to do this for a long time, so.
For the record, it was June 19th. I misread the date. I apologize to Mr. Huntley in the court.
It's all right, no problem.
All right.
Sorry.
You corrected me. Thank you for it.
All right, gentlemen, thank you very much. We are adjourned.
Thank you.
Have a good day, Your Honor.
Well, sir.
Okie dokie, friends. A lot of quicker hearings this morning, and interestingly enough, it's not a flooded morning out in the courts. Usually more action on a Monday than what we're getting, which surprises me because Friday most of the courts are going to take off, so I figured they'd be a little more packed than they are. But let's go. Oh golly geez. Back to Judge West. Let's do that.
I'm on your side. And are we going on just count one? Yeah.
Yeah, just count one with the priors for the day.
Right. Okay, give me a second. Okay. Getting there. All right, Mr. Williams, in cause number 24, DCCR 2242, the state's elected to proceed on count one only. It alleges that you committed the third-degree felony offense of driving while intoxicated, March 31st of 2024. The indictment further alleges that you were previously convicted of driving while intoxicated, March 28th of 2014, and also May 2nd of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And are those 2 prior convictions for DWI true?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Johnson?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that will be probated. You'd be on probation for 8 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. And that would include those 10 days upfront time. Do you understand?
Yes.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
Objection, Your Honor.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right behind you.
Okay.
All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor. I'll go take care of that right now.
Thank you, sir. Is there a way?
Alrighty, friends, back across the hallway. Judge Stevens.
All right. You are Jamal McCain?
Yes, sir.
Okay. You were here with Ms. Barroso, your attorney and the state's attorney.
Yes, sir.
You're charged with 3 habitual felony crimes.
Yes, correct.
So you're looking at 3 times 25 years to life imprisonment, 3 times that. In 23 CR 795, 3rd-degree felony of tampering or fabricating with evidence. You have 3 prior convictions in sequence, controlled substance, and evading arrest or detention with a motor vehicle. So you're looking at 25 to life on that. Unlawful possession of a firearm by a felon on April 18th of 2023, the same date as this earlier one. And the allegations are similar with the prior convictions. You're an habitual felon on that one. What's the date he was arrested on these 2? Anybody know?
I'm not sure, but I do know that he's been incarcerated for 3 years as of June, sometime first week of June, 4th, 5th.
Well, how long have you been representing?
Well, I was appointed in February. I'm his third attorney. His last attorney was Ryan Matuska, who we all understand has gone over to the federal.
I didn't know
defenders.
that.
Oh, I thought you were aware of that. Sorry.
No,
So he.
don't necessarily tell
Two
me.
previous attorneys that withdrew. I'm his third, I'm his second appointed attorney. I believe the first one was hired, which was Marcus Wilkerson. He ended up withdrawing. Mr. Matuska was appointed. He ended up withdrawing, and then I was appointed. And from my understanding, this is the first time that Mr. McCain has been before the court on asking for a bond reduction. And he's been there for over 3 years.
He was arrested June 22nd, 2023.
Often state was, I think, around the first part of June.
All right. So he's charged with those two. Then thereafter, before he was arrested, a few months later, a couple months later, he's charged with a
It was
murder.
a couple weeks.
This says April 18th.
Oh, I stand corrected.
April 18th, and then June 6th, which would be April, May, June. So I'm thinking about 6 weeks or 7 weeks later, he's accused of committing a murder. And in each of these three cases, he's classified as an habitual felon. He's finally arrested on
June 22nd.
He said that was for the murder. He was arrested June.
June 22nd. Well, finally arrested on something
Well,
on June 22nd of that year.
May 21st of 2023 on the tampering and the unlawful possession, and he bonded out on May 24th of 2023. And then he was
That is,
arrested.
you know what? Okay, I was curious about that because that's not in here anywhere in any of this. I swear, it's not. I don't have a 23. So hold on. So he commits 2 crimes. On now, habitual felon. He gets arrested, puts himself out, and then goes right out and commits a murder.
Well, Your Honor, it's
Is that
alleged.
right? Is that right?
That's what he is alleged to have done. Yes.
Okay. The grand jury decided that he did that,
Interesting.
and apparently the authorities. Okay. What's his bond?
At 1 million on the murder, 50,000 on the other 2.
All right.
The
What
bond was
else?
still good on the other two.
Okay.
I'm sorry.
The bond was still good on the other two. They're still open bonds.
Okay. It's $1 million is the
What
main
else do
one
you
that
want to
we're
add?
concerned about.
What else do you want to add?
Well, Your Honor, we would ask that Mr. McCain, if the court were so kind to reduce his bond at all, from the current amount of $1 million to whatever it feels is reasonable, that he be ordered to wear a GPS tracking device, that there be some strict conditions setting the bond. There's been no evidence that he's not going to appear for future court dates.
What about the evidence that he might be a danger to the community?
So let me just address the evidence, Your Honor, in the murder case. So there is a lot of digital evidence involved in this case. It's going to take a lot of time to review. We may have to end up hiring our own forensic expert.
Okay, what's stopping you from doing that?
Well, Your Honor, it's becoming a challenge to prepare a defense with Mr. McCain in jail. And I believe that he is entitled to a reasonable bond. He's innocent until proven guilty.
Unless proven guilty.
Unless proven guilty. But this offense is an alleged offense. He hasn't been convicted. He's been in jail for 3 years, and this is his first time appearing in court on a motion for a bond reduction. So I would.
That's terrible. That's a long delay.
Consideration.
That's shameful. I
Yes,
think.
sir.
I don't know what happened on this, but I'm glad you're in the ball game because you move things along.
Thank you.
State.
Yeah, we think the bond is sufficient due to the fact he was out on a felony, commits another felony. And we do have a little bit more than what she's saying as far as evidence is concerned. I have
the court finds that the bond is reasonable under these circumstances. These are extraordinarily serious, severe circumstances. He was arrested, charged with serious criminal felonies, and then thereafter is released on bond and commits murder in a few weeks. And the court finds this bond to be reasonable under these circumstances. We'll set it for trial.
Yes, sir.
Okay. Try to fast track this, please.
Yes, sir.
I'm not asking you, I'm asking her.
I think we're set for trial in September.
Yeah.
already.
Okay.
We probably already have.
Put that, I'd like that to be prioritized as number one. Mr. Laird, if you're going to be handling that, it's set for September.
Yes, sir.
That murder case, let's try that first. Thank you.
Wow, I just looked at the clock. We've just entered hour 3 of TCF Live already. Man, this whole year, let alone today, this whole year is just moving so fast. It's crazy. Let's do this. Let's go back up to Judge Prill. The contestant currently in front of him is in a suicide smock. We don't often see that right inside the courtroom. Usually we see that on Zoom, but this is in person.
People of the state of Michigan versus Lucas Paul Davidson. There are actually 3 files. 237028FH, time of day set for probation violation hearing. 267422 and 23, status conference. Mr. Davidson is present, represented by attorney Michael A. Morosky. People are represented by prosecuting attorney Timothy J. Rakowski. Court was advised that there may be a global resolution regarding this. Mr. Morosky, is that correct?
That's my understanding, Your Honor.
Very well. Mr. Davidson, as best you can, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Rakowski, would you please state the terms of any plea offer on the record, sir?
Yes, Your Honor. So as it relates to the 2 pending files, Mr. Davidson will be pleading no contest to both counts in file 26307422, which are the resisting obstructing counts, and being habitual offender third offense on each of the counts. People would agree to dismiss the other file, which was 26307423.
All right. And probation violation file, Mr. Morosky, is he intending to plead that one as well?
Yes, Your Honor.
Okay. Mr. Morosky, is that your understanding of the plea offer?
Yes, Your Honor.
Mr. Davidson, did you hear the terms of the plea offer on the record?
Yes, I just have I'm kind of confused about that.
Okay, take the time to speak with your attorney. I want to make sure you have enough time to speak. You understand everything going on.
Sorry about that.
No, don't be sorry. I want to make sure you understand everything that's going on. So is that the plea offer as you understand it, Mr. Davidson? Sir. I'm sorry?
Yes, sir.
And you wish to accept it?
Yes, sir.
Are there any other terms to this plea offer that we've not covered on this record? Mr. Morosky?
I agree.
Mr. Rakowski?
Yes, Your Honor.
Mr. Davidson, you are on probation to this court, correct?
Yes, sir.
You understand this could affect your probationary status?
Yes.
Okay. Have you had sufficient time to speak to Mr. Morosky about this?
But affect my probation.
About everything. I want to make sure. Okay. Do you need any additional time to speak with this?
No.
Anything affecting your mind or brain making it difficult to make court decisions?
Yes.
What? You don't understand what's going on?
No, I understand what's going on, but I have something in my brain that makes me have a hard time making decisions.
Okay. Have you talked to Mr. Morosky about that?
Yes.
Is it hard for you to make a decision right now regarding this plea offer?
No.
Do you have a clear enough mind to understand what's going on?
Yes.
And we'll go through your rights to make sure you understand it. But Mr. Davidson, I have to make absolutely sure that as you enter a plea or you decide you want to go to trial, whatever you wish to do, that you're doing it knowingly and voluntarily. Does that make sense?
Yes, sir.
All right. All right. The court is in receipt of an advice of rights. Well, actually, let me go through this as well. Mr. Davidson, according to what I understand, you'd be pleading to 2 counts of resisting and obstructing a police officer, habitual offender third. That carries a maximum sentence of up to 4 years in prison and a fine of up or a fine of up to $2,000. You understand the charge and maximum sentence regarding that? Sure. And a consecutive sentence may be imposed under statute if this occurred in a place of confinement. You understand that as well?
Does that mean being in jail?
Yes.
Yes, sir.
And I said could be. It's not mandatory, but it can be considered. You understand that? Yes, sir. In the second file, actually strike that. The second file will be no pursuant to the offer. And you recall when we had the probation violation arraignment hearing some time ago, all your rights relative to a probation violation hearing, do you understand those? Yes. Do you wish the court to go through those again? Okay, I want to make sure you understand those. And you understood the maximum sentence that could be imposed there as well, correct?
What is that again?
That is, I don't believe there was an habitual offender in that. That'd be up to 2 years in prison. You understand that as well?
Yes, sir.
All right. Understanding all of that then, Mr. Davidson, how do you plead to violation of probation?
The R&O one?
No, this would be the CSC 4 that you were on probation.
Not guilty. Oh, no contest.
No contest. Okay. Reason for the no contest, Mr. Morrison?
Potential civil liability, Your Honor.
I'm assuming no contest on 7422 as well?
Correct, Your Honor.
All right. Is your plea no contest to resisting and obstructing a police officer?
Yes.
And the same reason, Mr. Morrison?
Yes, Your Honor.
Any objection, Mr. Rakowski?
No objection, Your Honor.
Probably we can proceed in that fashion. Court is in receipt, and Mr. Rakowski, you may get that marked as well. Mr. Davidson, the court has received advice of rights forms. Oh, I'm sorry. Thank you. That was already marked. In the both files, 73, 22, and 23. You signed this document, sir? That's your signature?
Yes, sir.
Now, before signing it, did you read this document over?
That's my lawyer explaining it to me too.
Good. So your attorney explained it to you. Do you understand the rights contained on the form?
Yes, sir.
By pleading no contest, you're giving up these rights. Do you understand that?
Yes, sir.
Means you will not have a trial of any kind, nor have any opportunity whatsoever to contest your guilt. A no contest plea is tantamount to you admitting your guilt, and all that remains after today will be for you to be sentenced. Do you understand that?
Sir.
If these pleas are accepted, you'll be giving up any claim that these pleas are the result of promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim these pleas are not of your own free choice. Do you understand that? Yes, sir. Other than the terms of the line on the record by Mr. Rakowski, has anyone promised you anything such as leniency to get you to plead no contest?
No, sir.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. You understand that? Does anyone promise the court will be easy on you? Does anyone threaten you that with this plea?
No, sir.
Is this plea of your own free will?
Yes.
And also with that, you understand that court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that?
Yes, sir.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentences presumed to these pleas will be by application for leave to appeal and not by right. You understand that as well? Any questions of any of your rights? Any questions of Mr. Ronsky? Right. The court is in receipt of People's Proposed Exhibit number 1, which is a police report from the Huron County Sheriff's Office dated February 2023, and the complaint number is 259226. Mr. Morosky, any objection to admission of People's 1 for purposes of the factual basis? basis?
No objection, Your Honor.
Great, thank you. The court will review it. This is Lieutenant Newman's report. Yes. Mr. Davidson, do you acknowledge being previously convicted in this court on January 25, 2024 for assaulting, resisting, or obstructing a police officer causing injury?
Yes, sir.
And of assault with a dangerous weapon on that same date in this court? Is that correct?
In this court?
In this courtroom. In other words, you entered a plea to assault with a dangerous weapon on January 25, 2024.
I think so.
Take a look. Want to make sure to speak with Mr. Morosky about it.
Oh, yes, sir.
Okay, you acknowledge that?
Yes, sir.
And you acknowledge on April 15, 2024, you were convicted in this court of CSE 453.
Yes, sir.
Which is the probation that we have here currently in your case, correct?
Yes, sir.
All right. Mr. Rakowski, were any promises, threats, or inducements from this plea other than what's been disclosed?
No, Your Honor.
Mr. Morosky?
No, Your Honor.
Has the court complied with the court rule concerning the pleas, Mr. Rakowski?
Yes, Your Honor.
Mr. Morosky?
It has.
Mr. Davidson, there's no agreement made by this court concerning the pleas and what the final sentence will be. Is that accurate?
Yes, sir.
Mr. Morosky?
I agree.
Mr. Rakowski?
Yes, Your Honor.
Court will accept the pleas. They're done freely. They're voluntary and understanding. Any objection to the court taking judicial notice of the court file as well as the use of these pleas for purposes of probation violation file 237028?
We have no objection.
No objection, Your Honor.
Court finds that the pleas are done freely, voluntary, and understanding. Sufficient factual basis has been provided relative to the two charges of resisting and obstructing a peace officer. The court reviewed People's Exhibit number 1, which indicates that the defendant was under arrest, placed in the county jail on an alleged probation violation. And while in the jail, Lieutenant Ryan Newman from the Huron County Sheriff's Office, as well as Deputy Piotr, were attempting to control the defendant while he was in the cell. And there was active resistance by the defendant in that case. And as a result, there's a sufficient factual basis relative to that. As stated, the pleas that were entered will be the basis for the probation violation of the 23 file. We'll schedule sentencing for. We do the PV too. You want to do it all July 20th? I know the PV I could have done earlier. Mr. Rosner.
We would have no objection.
July 20, 2026 at 9 a.m. will be sentencing. Prior to sentencing, court orders an updated probation violation report in the old file. Obviously, a standard report from the probation agent, pre-sentence report in this matter. prior to sentencing, court, and that should be provided to counsel no later than 2 days prior to the sentencing date. Sentencing guidelines shall be scored 14 days prior to sentencing. Any objection to the scoring of the guidelines must be filed in writing or no later than 7 days from sentencing. The defendant must appear at the courtroom at the time of sentencing. If there's any objection to the scoring of the guidelines, it must be filed in writing with the clerk of the court no later than 7 days from sentencing, and notice provided to probation. Any objection or response must be filed thereafter. Any supporting documentation may be submitted to the court no later than 7 days from sentencing. Any objection or response must be filed 3 days thereafter. Bond in the files in 26, 7422, $10,000, 10%. Bond in the newest file, $3,500, 10%. Mr. Rakowski, your position on bond.
At this point, we just had some bond again.
We asked that those bonds be continued, Your Honor. Mr. Davidson has lived in Kenneth County most of his life. There's been no missing court dates that I'm aware of, Your Honor.
That will conclude the proceedings.
Thank you, Your Honor.
Hour 3 of TCF Live on a glorious Monday. Shout out to those of you watching our simulcast over on Rumble this morning. There's a bunch of you over there. So good morning to you. Let's do this. Let's change it up. Let's go to Fulton County, Georgia, Judge McBurney.
Mr. Jordan's not on the calendar. This is another one of the Ms. Wood's request. Oh, this was a carryover from last week.
Yes.
One of your clients had 3 cases. Is that this client?
Yes.
Okay. I don't have Thursday's calendar. So if you could get me those 3 indictment numbers, please.
So the oldest one is gonna be 21 SC 178640. And then there's a 26 SC 000824. And then finally 26 SC 000825.
All right. Now we can get on the record. Mr. Jordan, good morning.
Morning, how you doing, sir?
I'm all right. Ms. Wood tells me you actually were probably ready last week, but you are definitely ready now to enter a plea in the 3 cases. Is that correct?
Yes, sir.
Okay. Ms. Smith, the prosecutor on your 3 cases, is going to swear you in just a moment. Once you're under oath, make sure you answer all her questions and mine truthfully and completely. Will you do that?
Yes, sir.
It's also important that you let Ms. Wood or me know if you've got any questions of your own. Will you do that?
Yes, sir.
Okay. Then we are on the record with those 3 indictment numbers. And Ms. Smith, when you're ready.
Thank you, Judge. Mr. Jordan, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name for the court.
Kelvin Dwayne Jordan.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, no.
How old are you and how far have you gone to school?
50 years old.
You said 50?
Yes, sir.
And how far did you go in school?
I went to 9th grade, but I ended up getting my GED.
You did get your GED. Great.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these 3 indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
Okay. And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Jordan, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve one with the balance probated?
Yes, ma'am.
Do you understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to this felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you also understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Jordan, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 21 SC 178640, how do you plead to count 1, possession of a Schedule II controlled substance, count 2, driving while license suspended or revoked, and count 3?
Oh, please, just.
Hold on, let her finish and then you can ask me your question. Sorry, go
You
ahead.
good? Okay. How do you plead to count 1, possession of Schedule II controlled substance, count 2, driving while license suspended or revoked, and count 3, failure to obey traffic control device?
She's going through each indictment and asking how you pleading to the
I thought the charge got wrong. I thought I was pleading not to flee each other.
No, it's all 3 cases. Like we talked about with the jail for the 10 Circle and Club Prison.
Yeah, I plead this.
So here's where we are, Mr. Jordan. You don't have to plead guilty to anything if you don't want to, and you can have a trial, and the state has to bring in evidence to prove it up. You've got 3 cases from what I can see. One is real old. It goes back to February.
I thought the statute of limitation ran out on this.
Well, COVID is why it didn't run out. The state put the magic language in that indictment that the Supreme Court of our state paused the statute of limitations during COVID. And so it actually is a timely indictment. You were indicted in 2021 for something that happened in 2019, and that's within the range, and the clock was stopped in part by COVID. So in one case, you're charged with, I'm assuming it was a red light, running a red light, didn't have a good license, had a little bit of cocaine on you. That's the real old one. The newer ones, we got February of this year and July of last year.
Yes, sir.
We hadn't really gotten to those facts yet, but again, there were some driving issues. But today is the day to say, yep, I'm admitting my guilt, or at least I want to go forward. And we do what we call an Alford plea, where you say, it didn't really happen that way, but I still want to work the case out. Or you say, hey, bring it on, but prove it up. Bring in the officer who pulled me over. Bring in the officer who found the cocaine. Bring in the officer who chased me down when I was doing whatever you were doing in East Point back in July of last year. The state has that burden, you don't. But if you want to work things out today with this offer of 10 serve 1, then your answer needs to be either I am pleading guilty or it's in my best interest to resolve the case. But if you want it to be a trial, just tell me not guilty and we're done.
No, I ain't trying to do that. I got a question like, I'm trying to handle everything today.
Okay.
I was just trying to see, can I get like, instead of like a 10 to 1 year, can I get like 10 to 12 months?
So Ms. Wood can argue for things like that for you. I don't know legally that's an option because I think one of your convictions for fleeing and attempting to elude is a mandatory, it's a felony. And so felonies are years, not months. I know what your angle is because, hey, I could get, you're a smart guy. But I don't think with fleeing and attempting to elude, I could legally sentence you that way. But let's get through the part where if you're admitting to it, let's do that. And then we can get to what does the sentence look like, okay? So the question on the table was, how are you pleading to? Okay.
As to indictment number 26 SC 000824, how do you plead to count 1, fleeing or attempting to elude a police officer during the commission of certain crimes? Count 2, reckless driving. Count 3, willful obstruction of law enforcement officers. Count 4, failure to maintain lane or improper lane change. And count 5, failure to obey traffic signs.
Plead guilty.
As to indictment 26 SC 000825, how do you plead to count 1, theft by receiving stolen property? Count 2, identity theft fraud when using/possession identifying info. Count 3, driving without a valid license. And count 4, attempting to misrepresent a tag.
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction?
Yes, ma'am.
But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Yes, okay. Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Jordan. Your Honor, if this case were to proceed to trial, starting with the indictment ending in 8640, the facts would show that on February 1st, 2019, officers conducted a traffic stop on a red in color Chevrolet Spark for running a red light. When the officers got to the car, they introduced themselves and gave Mr. Jordan the reasoning for the stop and asked for his driver's license. At that time, the driver, who was identified as the defendant, told the officers that he did not have a license and gave them the name of Kelvin Jordan. When the officers ran that name through GCIC, they saw that his license was suspended and that he also had a warrant for a probation violation out of Fulton County. At that time, the defendant was placed under arrest. The officers then checked his person, where they found a substance that was later tested and tested positive for cocaine. And he was taken into custody and arrested for the charges we have before us. For the indictment ending in 0824, if this case were to proceed to trial, the facts would show that on July 16, 2025, officers of the East Point Police Department responded to a stolen car hit at 2838 Gus Thornhill Drive. That's in East Point, also in Fulton County. The officers saw that the car they were looking for was a red Chevrolet Spark, the same car from the last indictment. The officers then got behind that car to initiate a traffic stop. The driver was identified as Mr. Kelvin Jordan in this case. Instead of stopping for the officers, he fled the area, running through multiple red lights in a reckless manner with blatant disrespect for or disregard for public safety. He also made an illegal right turn, causing him to start driving down a one-way street the wrong way. The officers were eventually able to stop the car, learned that the person that was driving was Mr. Jordan, and he was arrested for the charges we have in front of us for this indictment. And lastly, for the indictment ending in 0825, if this case were to proceed to trial, the facts would show that on February 4th, 2026, officers of the East Point Police Department was patrolling around Calhoun Avenue and Bell Avenue. Those two addresses or locations are in Fulton County when they saw the red Chevrolet Spark with a test drive tag. The officers in this case initiated a traffic stop and informed the driver, who was identified as Mr. Calvin Jordan, the defendant in this case, for the reason for the stop. When the officer asked for his license, he told the officer that he did not have it with him and wrote down the name of Ashley Lyons with the date of birth of March 21st, 1973. The information was incorrect and did not belong to the defendant. When the officer ran that information, the description of the person who came up for Ashley Lyons did not match the defendant. The officers in this case was able to identify the car as being registered to a Justina Jordan. The officers saw that the car came back as stolen and was reported stolen. So at that time, the officers did arrest the defendant for the charges we have in front of us for that indictment ending in 0825. In this case, Your Honor, the state did try to reach out to Miss Justina Jordan, who is the registered owner of the car, or to see if there was like permission for him to get the car, since it was the same car in all three scenarios. We were unable to make contact with the victim in this case, or the person who owns that car. So we're not too clear on the availability of the defendant being able to get the car multiple times. However, those are the facts we have for those indictments. Regarding the recommendation between the state and defense, we've agreed to a sentence of 10 years to serve one for the defendant to complete an alcohol and drug evaluation, have gainful employment, and take an anti-theft course. And that is all from the state, Your Honor.
All right. Thank you. Ms. Smith-Mann, criminal history information on Mr. Jordan.
Your Honor, there are 40 prior cycles, not including the one that is before you today. There are 5 felony arrests, 8 misdemeanor arrests. There was a probation violation in 219. It does not tell me any additional information for that. And then there is a later probation violation, Your Honor, that does not give me a date. So hopefully probation will be able to help us with that. And that should be one past the 2019. Nothing further.
When you say 5 felony arrests, do you mean 5 felony convictions?
Yes, Your Honor. I am so sorry.
That's okay. So out of the 40 cycles, there are 5 felony convictions and 8 misdemeanor convictions.
That is correct, Your Honor. I
apologize for that. That's okay. I just want to make sure.
To do them as we were going because I didn't have this case. So I am so sorry.
Nope, you're all good. Thank you so much.
Okay.
Ms. Wood.
Thank you, Judge. Mr. Jordan is 50 years old. He's originally from Florida. He's lived here in the Atlanta area for the past 10 years. He does have family here, as you heard. He has 5 children. He does have a 9th grade education. I believe he has completed his GED. Your Honor, he struggles with cocaine usage. We actually referred him to drug court. He was eligible. However, there is a probation violation out of Clayton County and then a brand new case in Barnesville, Georgia, that
Involving the red Chevy Spark?
I'm not sure. But given those moving parts, and in speaking with drug court, and as you know, it's quite difficult to try to resolve other things to make it work, which is why we are hoping you will accept the state's recommendation in this case. One thing that I did forget to point out to Ms. Smith, so on the 2021 case, the one ending in 640, I don't know, it might make more sense. He did a significant amount of time. He actually got revoked, so he did about 26 months total since that arrest. And
he's been revoked on that for?
I don't know if it was the basis of other things, but he went to prison between 2019 and resolving this here.
Sure. What was the, basis for you going to prison?
I was on probation here in Fulton County. When I got pulled over for the cocaine and the marijuana, I was on probation here, and when I got pulled over, they violated it. They revoked the rest of my probation.
Got it. And that sent you down the road for a few years?
Yes, sir.
Okay. All right. Well, that'll probably resolve that one.
Yes, sir.
Ms. Simpson, it sounds like there's an active probation warrant out of Clayton County. Is there any Fulton probation still lingering that we ought to address here? Okay, thank you. Mr. Jordan, do you have any questions?
No, sir.
Your kids, how young is your youngest kid?
19.
So they're all grown.
Yeah, yes, sir.
Okay. The red Chevy Spark, that belongs to your cousin?
My mother.
Your mother. Your mother. Okay. Why was she reporting it stolen all the time? Would you take it from her?
Something like that.
Okay. All right. Is the Chevy Spark still out there? What happened to it?
I don't know what happened to it. I've been locked up.
Okay. All right. But that's your connection to it, is that it was your mom's car. And you might sometimes borrow it in a way that maybe she didn't
I
appreciate.
use the car all the time. She'll get mad with me and call the police on me if I don't come back.
It's a tough relationship.
Yeah.
Okay. All right. Well, Mr. Jordan, I find there is a factual basis in each of your three cases. Sounds like you've been wrestling with cocaine for a while.
Yes, sir.
It's too bad drug court won't work out right now. It doesn't mean that it could never happen. You've got to sort out Barnesville and Clayton. But if you get back here and are on probation and are tested positive, it may be that probation recommends that you go to drug court. That's not a sanction as in you getting locked up. It's an opportunity that might help you out. But we'll see how that plays out. I also find that your pleas are knowing and voluntary, meaning you've understood what we talked about. You agree with that?
Yes, sir.
And voluntary just means no one's forcing you to enter this plea.
Yes, sir.
Okay.
Yes, sir.
Ms. Wood, do you authorize someone in my office to sign your name and your clients to each of the three indictments?
Yes, Judge.
Ms. Smith?
Yes, Judge.
Okay. Let me figure out how to pronounce this sentence. So starting with 21 SC 178640. Count one, I'm going to sentence you to 1 year to serve. Count two will be 12 months to serve. And count three is 12 months to serve. Those will run concurrently with each other. So that's 1 year. I think that sentence is already done because of your revocation. I think the Department of Corrections will view that as that sentence is complete. In 26 SC 000824, this is the July 2025 Chevy Spark case. Which of these has a 10 in it? Is fleeing and attempting to elude is the maximum 10? I'm trying to figure out how you get to 10 to serve one.
Yes, it's 12 months to 10 years. Like it's 12 months to 10 years.
Okay. All right. Your sentence as to count one is 10 years to serve 1 year with a balance on probation. Count two is 12 months to serve. Three is 12 months to serve. Same with four and same with five. So that's a total of 10 years to serve 1 year, balance probated. Special conditions of your probation. Number one, stay away from the red Chevy Spark. Just resist the temptation to drive that, because they're going to see you and say, there's Mr. Jordan in that red car. East Point probably has a photograph of you in that car in each of their patrol cars because they're going to pull you over. Number two, when you are out, you will get a drug and alcohol abuse evaluation. And if they recommend any treatment, that treatment is part of your probation. I'm also going to require that you have at least 3 random drug screens each month for the first 6 months of probation. If you are blowing those up, that'll be a reason to get you into drug court or into the day reporting center, which is another way to get you some drug treatment, some job readiness, things like that. But I'm not going to require those because it may be that when you are out, you aren't testing positive. Finally, in 26 SC 000825, That's the most recent one from February of this year. Count one, what's the range for that theft by receiving?
1 to 10, but let me double check. I'm gonna say 1 to 10, but I'm verifying right now, Judge.
Okay. I just don't want to give you an illegal sentence because then we have to do it all over again. Yes, it's 1 to 10. All right, so count one is 10 years to serve, 1 year, balance probated. Count two is 1 year to serve. 3 and 4 are both 12 months to serve. So same sentence, it'll run concurrently with the other case and the same conditions of probation. Stay away from the red spark, drug and alcohol evaluation and treatment. I'm going to waive your probation supervision fees for the first 3 months after you get out so you can get situated, settled, maybe start working. And I think that covers everything. Ms. Smith, anything else?
Nothing further. Thank you.
Ms. Wood?
No, Your Honor, thank you.
Okay. Ms. Simpson, Mr. Jordan needs to report 48 hours after release.
His probation is
Okay. Is that where home is, Clayton County?
No, I stay in Atlanta.
Okay. Well, when you are released, whatever your home address is going to be defines where you report to probation. It's the county of your residence.
I probably had to get my probation transferred.
Okay, well, they'll train. I mean, you show up to a probation office and say, here I am, Calvin Jordan, and you provide proof of residency wherever it is you're staying. And they'll say, I mean, you could have been in Cook County, and they'll move it to Fulton if that's where home is.
Yes, sir.
Okay. All right, good luck with things.
All right, thanks, sir.
Bye, Mr. Jordan. You're welcome.
In the final half hour now of TCF Live, Michael and Barbara, thank you both for each gifting a membership. I very much appreciate that. Let's go back to Judge Stevens in Texas. The woman approaching, I believe, is the same one we saw a week or two ago who was all like giggly and happy and a little bit weird, and the lawyer was saying that he wasn't sure his client understood him, but Stevens was saying, well, I've got the psych report right here and she's fine. I think this is her.
All right, we now call 25 CR 554, the state of Texas versus Miranda Folan. Is that you, ma'am? And you're here with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary? Yes. Yes. In summary, Miranda, this she's on a motion to revoke probation, right?
Yes, sir. And she's,
You were earlier indicted for criminal mischief, and you were placed on 5 years deferred or unadjudicated probation for that after you pleaded guilty back in November. And I'm disappointed because I wanted to see you successful on this. And does she waive this formal motion to revoke unadjudicated probation? Can we proceed in summary?
yes, sir.
Please raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke probation. Looking for the date it was filed. I don't have a date on this for some reason. That's odd.
The date the motion was filed?
Yes, ma'am.
It should be March 5th of 2026.
Yes, it's not stamped on this one. Nonetheless, it was filed. on March 12th, 2026, according to the file. Yeah, see, I don't got one with nothing.
Yes, sir.
For some reason. We need a copy of this for our file, though.
Just it may be in the computer.
In summary, this motion states that on November 17th of 2025, last year in this court, you were placed on 5 years deferred or unadjudicated probation for criminal mischief. Is all of that true? A state jail felony? Yes. Okay. Allegation, what's she pleading to?
The first one, which is one felony case.
One. Allegation one states you committed the offense of assault causing bodily injury to another on or about December 18th of 2025 in Orange County, which is a violation of condition 1 of your probation order, which states do not commit an offense. Is that allegation true? Or yes? Are you pleading true voluntarily and because it is true after discussions with your attorney? Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes. You want to plead true today, move forward? Yes.
Yes.
An agreement has been reached where your probation would be revoked. You would be found guilty and sentenced to 1 year in the state jail. Is that your understanding of the agreement? How much time does she have credit for? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yeah.
Also, there's a case in Orange County, isn't there, for assault?
That's correct, Judge.
Is this? And that's what allegation 1 is here.
That's correct.
Out of Orange County. All right. I intend to follow this agreement. If I do, you have no right of appeal of your case. Do you understand?
Yeah.
Anything else to add by anybody? If not, I'm going to find as follows that Miranda Folan, you have pleaded true to allegation 1 of this motion to revoke unadjudicated probation voluntarily, knowingly, intelligently. That is committing the offense of assault causing bodily injury to another on or about December 18th, 25 in Orange County. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation can now be revoked and you can be found guilty. I grant this motion. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, which was just a month before you committed this offense, you were placed on probation, by this court. You had pleaded guilty to this underlying criminal mischief case, a state jail felony, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea at that time. During your plea hearing, finds you guilty beyond a reasonable doubt. Even though we deferred any finding of guilt, that deferred or unadjudicated order of probation is hereby revoked. You are now found guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for a term of 1 year.
Just 281 days credit.
All right. You've got over 9 months credit. So they're going to take you in and you're going to have to complete the remainder of about 3 months. Do you understand, ma'am? And then you will be released. What are you gonna do when you get out? You have a plan? Who are you gonna live with? Nobody. You're not, are you homeless? Oh, okay. Where's your family?
No, they're.
You don't know where they are?
No.
Nobody? Nobody in the family, you know what? Where were you born? You don't know? But what's your date of birth?
September.
How do you know that? No, how do you know that? If you don't know anything about your family or anything.
Yeah.
Okay. All right. That's a sad deal. Well, you're gonna do better. Promise? Okay. Best wishes to you, man. Okay, that is all.
It's TCF Live on a lovely, lovely Monday. Good to have you all here. A few more minutes left. I want to go to Judge McAnally. I've got no idea what this is about, but I just glanced up at the big board with like 25 feeds on it, and there's this large dude who looked really animated. So, no idea, but let's see what this was.
Are you going to calm down?
Yes.
I don't need you yelling at me. Do you understand?
Yes.
Good. Okay. I'm going to let you start. I've got everybody here. I have Ms. Thomas, Mr. Thomas. I also have Ms. Howard and Mr. Stone. So you tell me again, you bring your car in, and I remember you talk about yellow, red, green. So talk to me. Go ahead and tell me. You're all under oath still.
So I bought a car from a dealership at an auction. And the car, after a couple days, was messed up. So I talked to my wife and I told her I don't feel comfortable. I could easily put it on Facebook and bet somebody in a parking lot at letting somebody get it like that. So I told her I would take it to an auction house. When I stepped in the auction house, me and my daughter, we asked the lady at the counter.
Who was it? Is she here?
I brought her last time. She's.
No. The lady at the counter. Who was that? What was her
I
name?
don't know if it's her or not. I don't think so.
Kim, she's not here.
Okay, go ahead.
I asked her, I said, could you tell me the difference between the lights? Which, by the way, don't make a difference because I've read 11 different reviews in the past 6 months on this guy's site that are 1 star from a green car that quit the very.
I don't want you to go into that right now. I just want to explain the light
I'm
situation.
just saying, sir, it doesn't mean much if they're buying green cars that are quitting.
Sir,
what the difference is a red.
Just tell me what you were told.
So the lady told me a green car is something that their mechanic takes out for a test drive and declares that there's no mechanical issues. And then the yellow car, I forget what she said was for. And then she goes on to red car and she tells me a red car could have engine problems, could have transmission problems. And me and my daughter both at the same time go, yes, it's got something wrong with the transmission. She goes, oh, okay. And then I asked her if there's anything she needed me to sign. She handed me a piece of paper, told me all I needed to do was sign at the bottom. And then the lady even said that she was the lady who sits at the desk at the computer when they do the auctions and whatever. Then after the car got bought, I got a call from her asking me if there was any problems with the car.
So you signed saying this was a what?
Red light.
Red light?
Yes.
Okay.
Then I got a call after I sold the car several days later.
Do you guys dispute that at all?
I can, I just was letting him speak.
Okay, no, I just want to make sure. Okay, go ahead.
I got a call from her.
The plaintiff.
Yes. And I told her, I'm sorry about your loss, but I sold it as a red light car for a reason. Then I got a call from him. Who told me
dad.
He was a police officer and this wasn't going to go my way.
Her dad.
Yes. Then I called up and talked to, I think, maybe him.
Mr. Stone.
And I told him that I talked to a lady in your guys' lobby who had told me what the difference between the 3 red lights were, and that we told her that it would be a red light because we told her it had transmission. She marked it as a red light. Then he gave me an excuse that, well, some cars that come across my board are red light, but they work. And I asked him, what was that excuse? And he says, well, when a creditor takes a car from somebody, all the cars run as a red light. And I'm in my head, I'm thinking, okay, but a creditor takes a car from somebody, they don't want to take a chance at having it on the road and then them selling it as a green light and it has a problem, so they mark them all as red. Because when it sells, they chase the person they took it from for the rest.
Okay,
So
hold on, wait, just don't get excited.
Go ahead, run with that.
Did he do this as a red car?
Yes, Your Honor. He did sell it as a red light car. This is his original contract here. And I highlighted this after he did not sign it with a highlighted. I just want to say that for the record. I didn't.
Okay, hand that up. You can hand it right to my recorder.
I only highlighted so that way when I called him, I could quickly refer to it.
Okay.
That is a consignment form for a public seller. It's basically stating that if there are known transmission issues, it must be announced.
If the vehicle is properly functioning transmission unless otherwise listed above in announced conditions. There's nothing else announced conditions. All it says is extra key in office.
That is because when I talked to the lady at the desk, she told me that she was the lady who auctions the cars off. She's there at every auction and that she would remember. And I asked her if there was anything I needed to sign. The whole reason I found out it was a red car is because I asked her, tell me the difference. And when I told her, me and my daughter told her, it's transmission issues, which she heard. She says, okay, we got to mark it as a red car then. I said, is there anything else I need to sign? She said, it's just at the bottom right here. And I walked out. And even further on, the car blue book value was worth more than they bought it for. They should have just put a transmission in it and carried on their way. How are you going to buy a red light car and expect it to drive and work and function properly?
Okay. What else can you add, Mr. Stone?
So I had called Mr. Pierce, and I had said to him that the customer had issued with transmission, and he said that he knew that, that's why he sold it through us. Otherwise, he could have just done it himself, which I would like to think that if he did sell it out of the marketplace himself, he would tell that person well. But it was more or less like he was put the burden on us. So typically when there's an issue with a vehicle like this, we do call the seller and see if they can provide some kind of assistance to help with the buyer in this case. And he was not willing to do so.
You paid $4208.10 for this, right?
Yes,
Where's the vehicle now?
I sold it through the same auction.
How much did you get?
1,609.
I have that before this one.
I'm gonna also say, Your Honor.
Hold on. Did she sign a document like this?
She did, and we announced transmission issue.
Let me see.
It's okay for us this year to look.
Yeah. What else do you want to say while he's looking for that?
Yeah, so I bought the car for $7,500. The very next morning, I stuck 500 into it. A week later, I rolled it over to auction and lost 4,500.
I know, but you can't pass on your losses to somebody else.
I've already declared to their place. That's how it got listed as a red light. It's telling the lady it had transmission problems. Now it's just hearsay. You told them hearsay last time.
Listen.
But what he's saying is hearsay if he didn't bring the lady here that I talked to.
It was not subpoenaed to come back.
Please. You get way too angry. If one
Sir,
thing,
I've lost everything in the last 2 years. 3 vehicles.
Sir.
I've been outside in the truck with the broken window.
sir,
I got the truck. Sir. What kids does anybody here have?
sir. Settle down.
It's hard when you do the right thing and you keep getting screwed over.
Mr. Pierce, maybe you need to talk to somebody, okay? I mean, you are acting so childish right now. I can't even imagine. You came up here with piss and vigor from the very time that I called your case.
I shouldn't even be here right now.
Really? Okay. I'm glad you feel so confident about it. I want to know why did the broker fee agreement change from April 9th until June the 5th?
I'm sorry, what I gave you was a copy of, the bill of sale for her. I do not have the, her signed rules.
Well, did she sign a seller's consignment agreement / broker fee
Yes.
agreement? Where is it? Do you have it?
I'm sorry.
Do you have that seller's consignment agreement?
No, I don't see it.
/ broker fee agreement? You have everybody execute one of these, right?
Yes.
All right, so let's find the copy that she signed. Somebody's got to find that for me.
Okay.
Call over to the office.
I left my phone in the car. I didn't know if I could bring it in, so.
You can go out there. I'll wait. Have them. Where am I going to have them send it, Jennifer?
They can email it to me, Your Honor, jen@33court.com.
Jen@33court.com. Real easy. Jen, Jen @33court.com. Not 33rd District, 33court.com. I'm going to keep going while he's calling. Ms. Howard, what part did you play in this?
I received a phone call from Avery that
When?
it was, April, April 17th.
The day that she bought it?
Left. No, that was.
No, she bought it on the
16th.
looks like the 11th.
Well, she paid for it though on the, we give the customers a few days to
Okay,
pay. So
okay.
she paid for it on the 16th, and then she had left with the car on the 17th, and I believe it was in the morning, she had called and said that, the car wasn't running. She had drove that morning, she went to go somewhere and the car broke down, and as our policy, I told her that she would have to, take it in and get it diagnosed, which she did. And then I told her that there wasn't a lot we could do because the seller's already been paid. Sometimes in those situations, we can hold the check till they get a good diagnosis. But the timing was that happened, he picked up the check, so at this point, the only thing that you could do would be to call the seller. We give all the seller's information on all the paperwork that she signed, so she did call the seller. He then called back asking why did we give her his phone number. I did explain it is on all the paperwork, and that he just didn't want, that's why he brought it to the auction, because he didn't want any problems like that.
Because you didn't want any problems like what?
Because I could have took it and I could have sold it on Facebook and got all my money back.
How can you say that?
Because that's what people do. But
Well, one crook doesn't justify another.
I didn't crook anybody. I walked into the auction house and me and my daughter asked the lady to go through the 3 lights. When she said red light was either for an engine or transmission problems, we said it has transmission problems. The lady said, okay, I'm gonna mark it as a red light.
So you got.
And now I'm sitting here getting told that I'm trying to crook people. And you don't think this is one-sided?
Settle down.
Oh,
John, I got it. What I'm saying is you're telling me that you got essentially, that there was a fraud perpetrated on you when you bought it. And now you're saying you could have sold it on.
I bought the
Stop. And now you're saying you could have sold it on Facebook and gotten all your money back, which means you would have had to tell people there was no problem with the vehicle. So you're not exactly making yourself look good.
My daughter sat right here and told you, she walked through the door with me and told you that she listened to the lady explain the 3 lights to us. You didn't listen to that.
Don't tell me I didn't listen. You are really, 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 I don't know what to tell you. You're not a very nice man, okay? You really are acting like a child. I'd listen to every word. Do you think with the number of cases I hear that I remember every word that was stated to me 2 weeks ago? I said that right from the beginning. I don't remember everything. And now you're saying you didn't listen to her. What an accusation to level at somebody. I don't care if I was selling fries at McDonald's. What an accusation to level at somebody. I take this seriously. Stop with your personal attacks.
Can I say what the lights?
Sure.
The green light, when the customer wants it on a green light, that means that our mechanic, after the customer puts their deposit down on the vehicle, and this is for a green light, our mechanic would take it for a test drive. We have things that are listed as arbitration. One of the biggest things are like a lower engine noise or transmission. So that's what the green light gives a customer. The red light vehicle, we don't sell, like, they're not, all red light vehicles aren't just a bad engine or a bad transmission. It's totally up to the sellers what they want to do. We have our banks are always just automatically a red light. Banks don't have, they haven't checked out the vehicles, things like that. So it's just automatic red light. We sell donation vehicles that are just automatic red light, just because of who the seller is. And then up to anybody else, it's up to them. The red light somebody might put a red light on it because it's over 100,000 miles, or it's just, it's up to the seller. They can do the red light. The yellow light means that so you could have 2 lights on. You could have the red and the yellow. The yellow is always an announced condition about the vehicle, so that could be something that we found from auto check, something that the seller told us. So that would be the reason why the yellow light is on. And then we would have the red light. The red light, it's a red light, and there's a yellow light because of, let's say, the transmission. So it's not just that we run red light vehicles that are just bad engines or bad transmission.
It could be a variety of different reasons.
Right.
And I get it. Did you find it?
Yeah, they are scanning it and emailing it right now.
Perfect. Can you tell me without looking at it whether or not she signed the same document that Mr. Pierce signed?
I'm sure she did, but I have not seen it.
Well, if you're going to defend this on the basis, just tell him.
Well, it is all the same documents.
I'm just telling. If you're going to defend this on the basis that we didn't know there was an engine problem, and Mr. Pierce signs this, and you're going to highlight that portion that you've handed up, and I'll read it into the record, that the vehicle is properly functioning transmission unless otherwise listed above in announced conditions. I'm going to trust that when she signed this, that she crossed that out or somebody crossed that out, because at that point you guys knew that there was a bad transmission.
Yes.
So you can't just hide behind lawyer legalese here either and start with all these fancy words. You're going to indemnify us and hold us harmless. Well, that's all nice. But I don't care what's in writing. If somebody's perpetrating fraud, and I'm not saying you are. I'm not saying you are. I'm just going to point out to you and to this young lady that if her language that she signed is the same as his, you can't come in here and say he knew, and this is in paragraph 4. And or whatever it is, paragraph 5, that the vehicle is properly functioning transmission unless otherwise listed above in announced conditions. Now, if you included bad transmission on her document, that's going to be fine, or she did. So I'm going to wait that. I'm going to get off the bench here. I'm going to wait for that document and I'll check it out and then I'll come out. Okay. I'm going to ask you all to just be, thank you. You guys can go ahead.
Alrighty, friends, we're in overtime here at TCF Live. The good news, this hearing is fully brought to you by the Wayback Machine, so we're just going to power through this little pause here and pick it back up. Here we go. They're approaching again. Let's continue.
I just want you to know she did, so I'm going to read this. Everybody's in place. On number 5, and she signed that the vehicle has properly functioning transmission unless otherwise listed above in quotes announced conditions, end quotes. I want you to see this, Mr. Pierce. Come on up and just take a look. We're under announced conditions. Why don't you tell me what it says?
I'm not interested in looking at it because I've already told you, and my daughter told the lady I had transmission problems. The lady handed me the paperwork, the lady deals with the paperwork, the lady told me all I had to do was sign the bottom, and that's what we did. You didn't want to hear my daughter, you don't want to.
I'm not happy. I gotta tell you, top 3 most disrespectful that I've had in here in 32 years. Who do you think you are?
I'm not trying to be disrespectful.
Well, I gotta tell you, you must do it naturally then. You're like a know-it-all. Give me that back. I'll read it to you. Announced conditions. It's a transition. Transition.
Yep.
So that she disclosed that. You didn't. All this says under announced conditions is extra key in office. And you already slipped up once or twice, at least twice. And I'm just trying to get to the bottom of this, even though you've been belligerent. You already announced twice that you weren't going to go on Facebook. You thought you could have gone on Facebook and got what you paid for it. What does that tell me? So yeah, I stand by my words. You were the victim of a fraud and you contemplated perpetrating a fraud on others to cover your bases. You know you said check. Well, you checked red light. Nobody said you didn't check red light. I don't think they ever said you didn't check red light.
I asked the lady if there was anything else I needed to do when I signed the papers. The lady said, just sign it at the bottom. Me and my daughter looked at that lady and she read the red light. When she said red light, she said, well, red light could have engine problems or transmission problems. And my daughter said it before me. She says,
why don't you get this lady on Zoom? Is she working today?
Yes, sir.
Call her up. Get her on Zoom. You can call right from there. I'm telling you, you got to control yourself. I mean, I got to tell you, I haven't been this angry in a long time because I haven't had anybody be this disrespectful.
I need Kim on the phone, please.
What is it, John, again? 448?
415-2931.
Ask her to zoom in. 448.
Okay, so does she have the Zoom app on her phone?
Do you have Zoom on your phone? Yes, we're in court and
I would like to talk to you. You can either drive here
the judge would like to speak.
or you can zoom in.
Okay.
She need the ID?
Yeah. Yes.
We're right in the middle. We're in the courtroom now. Listen, I'm getting off the bench for 5 minutes. They're going to give you the Zoom ID number. You zoom in. We're going off the record. Everybody, all of you can have a seat, and you're going to tell her the Zoom ID.
I'm going to give you the Zoom ID.
Well, my friends, this is why you watch TCF Live every morning, because you just never know what you're going to get. You really don't. Again, we are fully in the Wayback Machine on this one, so we will power past this little break and continue and see what's next. Oh, there's the lady. All right, here we go.
Your name, please.
My first name is Kimberly, Kimberlee. Last name is Amezcua, Amezcua.
Amezzua?
Correct. Amez as in zebra, Cua.
CUA. I wasn't sure. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes,
You're employed at the Greater Detroit Auto Auction, correct?
correct.
What is your job title?
I am an office worker.
What are your duties?
I check in vehicles that come through, help with paperwork. Do RD-108.
Do you know this gentleman, Mr. Stephen Pierce?
He had dropped off a vehicle to sell at the auction.
Do you remember your conversation with him?
I do. He dropped off a vehicle to sell, a Ford Fusion.
Okay. And what was the content of your conversation with him?
So he had brought in a vehicle to sell. I had asked him if he wanted to sell the vehicle red light, green light. Green light means that the vehicle is in working order. Trans and engine are good. Red light being sold as is. He said he wanted to sell the vehicle green light, that the vehicle was in working order, that there was no mechanical issues, there was no trans issues, and he wanted close to $6 grand.
Okay. And ultimately, though, on the agreement, he checked the red light box, correct? Or somebody did?
I did, because he wanted to sell it red light.
I thought you initially said he wanted to sell it green light.
Well, correct. And then he said he wanted to sell it as is.
So what caused you to check? That's your printing, if you will, on the vehicle description, color, VIN number, sale date, and title number, correct?
Correct.
What caused you then to check the red light box as opposed to the green light box?
Because he said he wanted to sell it as is.
Okay. But he'd already told you that he had some transmission problems, correct?
He never said that it had transmission issues.
Never said that at all.
Transmission issues was never brought up when he brought in the vehicle. He said he had put some work into the vehicle, but he had never said that it had transmission issues.
Okay.
If he had mentioned transmission issues, I would have to write that down. Prior to me working in the office, I have worked in the yard for 4 years. Anytime there is a vehicle issue such as trans, mechanical, a bad engine, we have to announce that per our auction rules.
Do you have any questions of her, Mr. Pierce? I'm gonna let you ask her questions. Yeah.
Ma'am, do you remember if I was with anybody?
I believe you were with a female. I don't know her relation to you.
My daughter? Ma'am, do you remember me asking you if you can explain the 3 lights to me?
Yep, a red, a green, and a yellow.
You remember when you said red, you said it could have engine problems or transmission problems, at which my daughter said, yeah, it's got transmission problems. I said, yeah, we don't know what's wrong with the transmission.
Trans was never mentioned. I have a very good memory. A very good memory.
Do you have any other questions?
No.
You sure?
Why, if they're just gonna deny it?
Sir, I'm not quarreling with you.
I walked in with my.
Sir, I'm not quarreling. I just want to know if you have any other questions for her. Do you have any questions for Ms. Amezcua?
No.
Do you Sir. You said liar?
They're lying.
Okay.
My daughter was right next to me and heard the lady say, okay, then we're gonna have to mark it as a red light. After we told her it had transmission problems. The whole reason we asked her to tell us about the 3 issues is so we could justify it under the right light. And she can remember that I asked her, but she ain't gonna throw her company under the bus, is she?
Let me ask you a question. You said you received how much for the vehicle?
When I sold it,
Yes.
1,690.
1609?
1,690.
90 or 9?
90. 1690.
Okay. And you paid 4208, 10. What, how can you sue him for 6,000?
That was before I sold the vehicle.
And also, she had a receipt when the day the vehicle went down, she was able to pull into like next to a service station. And, her grandfather came up there and they had tried to, flush the transmission, paid $250 at the service station, trying to, figure out if that would help the vehicle that day. So they have receipts for that and just.
The point is, you don't have any other out of pocket. The only thing.
Just the $250 does not add to that.
And I only got 30
Slow down
from the auction house.
And the 250 was for what?
To flush the transmission on the vehicle.
And who was that bill from?
Lane. Have that.
Is there anything you want to say?
No more is there to say?
No.
No, sir.
Giving you every benefit of the doubt. Tried to bring in, I made them bring in this witness. I made them bring in these other witnesses. This young lady here, this Kimberly of Mesqua, seems very, very, very credible to me. On the new consignment agreement that this young lady, Ms. Thomas, signed, it clearly spells out transition. I don't believe that you ever told her, and I know you're going to disagree. I'm just telling you why I'm holding like I'm holding. I don't believe you ever told her that you had a transition. I believe from her testimony for sure that she would have told you to note that on the seller's consignment agreement, which is why I wanted to see Ms. Thomas. I don't know why you're blaming everybody else, but that's neither here nor there. The plaintiff asked for $6,000. The plaintiff paid $4208.10. $1690 was the amount that she got. So there was a differential of $2518.10 plus the $250 for $2768.10. And she is entitled to her court costs. What did you have in terms of court costs? I see on here an $80 filing fee. Did you have any other out-of-pocket expenses?
Yes, for the subpoenas.
I'm sorry?
For the.
Well, tell me what they were. I need somebody to tell me. You need to tell me, young lady. It's really you.
75.
75.
So $75 for subpoena, what? Process of service fees?
Yes.
Service of process fees, I should say. So you have 80 plus 75 for 155.
Your Honor, did you get those service fees? I'm sorry. I'm showing 3625 is what Dino filed.
She said $75 in subpoena fees. Is that accurate or incorrect? That's what I meant for service of process fees.
Let me look at the actual subpoenas. I'm showing 3625 on them. which would be
Got
$72.50.
$88 in a filing fee.
Correct.
Okay. $88 in a filing fee.
And
What
the
else?
subpoenas were each $36.25, so $72.50 in service fees of the subpoenas.
Is there anything else? That she has, just those two,
Just those two subpoenas and the initial filing fee is the only things I'm showing.
so according to my total, it's $2,928.60. That is the amount of judgment.
You're telling me I got 3,200 from them for selling my car, lost 4,500 when I bought my car, and now I gotta pay them 2,900? Yeah.
I'm sorry you got defrauded. I really am.
A lot of sorries.
Listen to me, Mr. Pierce. You sound like a very angry man.
Because I know that lady's lying.
I know she's not. I've been doing this. I know she's not.
Cause I'm a crook, right? That's what you just labeled me.
There are days. I'm not gonna argue with you, sir. I'm so convinced I'm right on this. That's it. That's the judgment amount. You need to figure out how you're gonna pay them. How are you gonna pay them?
I don't know, because I was in a crash 15 months ago. I've lost the 2019 Ford Ranger. I've lost the 2024 Harley Davidson, and I got a truck out there with a blown window, doesn't have AC in it, and I tried to do the right thing here, and I'm getting screwed over.
Do you work?
I can't work right now, sir. I'm physically unable to work. I broke 5 bones below my waist. My wife had rolled me on the side of a bucket. The same company that you're trying to defend has 10 different 1 stars for green lights. Green lights, if they quit within 24 hours, they're supposed to give their money back. They got 10 people complaining they ain't got a dime from them for green lights. They quit the next day.
I am not defending anybody. I'm sorry you disagree. I really am. I'm sorry you're going through that. I really am. Maybe that explains why you're so angry, but I did the right thing here, as I do every day. Here. Good luck. You guys are going to have to check into how you're going to collect on this, okay? So specifically you, Miss Thomas. Good luck to everybody. If you need any of these documents back, John, take them all down and see what they want.
Okay. Alrighty, friends. I'm going to just hold my tongue on this one. I'm sure I'll have more to say in the intro when we clip this, and this will be clipped. This will be its own video. But I hope you all appreciated hanging around, and thanks for hanging around with me for overtime for this one. Just stumbled across it. There was just something about the way that guy was carrying himself that I was like, we need to watch this. So I hope you all enjoyed. Lone Wolf, thanks for hanging out with us in the chat today. Appreciate that, my friend. This evening, do check out Lone Wolf when he is live, 9 p.m. Eastern, 8 p.m. Central, which would make it 6 p.m. Pacific and 7 p.m. Mountain, something like that. Go find him. I just dropped a link, so check him out. He's got a good channel. And we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. If you're a channel member, join me a half an hour earlier for the pre-show. The wisdom I leave you with today comes from Dan Martell. I guarantee I'll F up again. Let's just make sure I make a new mistake. Good advice. Thank you so much, my friends. Go enjoy your day. I look forward to seeing you all again real soon. Take care. God bless.